Good morning, good morning, good morning, Law Nerd. It is Tuesday. It's February 11th. Time is a construct. I can't believe it's February. Lots has happened today. I am a little under the weather, so apologies on the voice. Do I know what it is? No, it's the time of year where it could be travel, it could be the flu, it could be allergies, it could be that I'm just old and tired from concerting. Who knows? But the voice decided to be sassy today. But today, we have lots on the docket because the Supreme Judicial Court of Massachusetts finally issued their ruling in the Karen Read case. Plus, Karen Read's lawyers filed a number of motions. They have more motions that will be coming today. We're going to go over one of those motions, but today is a deadline for motion filings in Massachusetts as well. So we need to go over what the Supreme Judicial Court did. We need to go over this new filing from Karen Read's defense team from yesterday. We had some other things on the docket today that's getting bumped. Don't worry. We're just going to bump. That's what's going to have to happen. That's just what's going to have to happen because there is too much going on in the law. So for everyone who may have seen news headlines, Twitter headlines, YouTube thumbnails that have spoilers on them, some people don't know what the Supreme Judicial Court ruled yet. So thank you for not being a spoiler. Spoilers are the worst. The worst. So thank you. I appreciate it. What's not a spoiler is members. We have some information for you later today on some upcoming things. So if you are a member, be excited. There is information coming to you today about stuff that's happening tomorrow just for our members. So be excited and hang in there, and we will get into all of it. Do not worry. Yes, the voice is under the weather. It might just be because I am over the age of 45 and can't go to 2 concerts in a row. It might just be because I flew to Arizona and everything was like, I'm allergic to this state. It was windy and my body was just like, wind, I reject you entirely. I didn't waste management hard enough to feel as badly as I feel. I'm so mad. I should be able to hang, but no, I can't. And to everyone in the chat who's going to be offended by what I say next, I'm not sorry. My family's from Philly. Go Birds. I'm not sorry. I'm sorry that you're sad. I don't love that for the Kansas City fans. I'm sorry that you're sad. But I'm not sorry that the Eagles won the Super Bowl. I'm just not. I'm not sorry. I apologize for nothing. My dad is absolutely thrilled, and I'm thrilled. My dad is thrilled. Look, go Birds. Go Birds. That's it. Just go Birds. I'm sorry. I'm sorry for those of you that your soul is crushed. However, it was time for some Eagles payback. It was needed. It was deserved. The meme and epic. I don't know what happened to your quarterback. I don't know. Kansas City, I'm sorry. I don't know what happened to your quarterback. I really don't. But go Birds. I mean, again, for a kid who grew up in California, my parents met at the Jersey Shore and grew up in Jersey and outside of Philly. So, it's one of those life things that when I was a kid, my parents were like, go Eagles. And I'm like, go Cowboys. Because I was an asshole as a kid, as most of us are. And my parents are like, what? And I was like, go Cowboys. Go Cowboys. And then my parents were like, I think we need to disown you. And then, California has all the California teams. Go California teams. Couldn't wear Raiders gear around once I became a DA because I was just like, well, that could be a problem. And then moved to Tennessee. And while I enjoy the Titans, I am so excited for the Eagles and for the Eagles fans. I just am. Also, do you know what I'm a fan of? I'm a fan of the shade. Kendrick Lamar brought the most epic shade to the halftime of the Super Bowl that I have ever seen. It was just levels upon levels upon levels of shade. And then, is it a flare leg, Gene? Is it a flare leg? The outfit was everything. Serena was fucking everything. Like, it was everything. It was everything. It was everything. If the rest of my internet feed for the rest of my life is Kendrick Lamar going, say Drake, I would be a happy girl. I will be a happy girl because that grin, oh, it was so good. The Uncle Samuel L. Jackson, it was on so many levels. I think I'm still unpacking the layeredness of that performance, and I'm here for it. So for those of you who saw my podcast episode, it got a little bit restricted because I played too much of Not Like Us to make a point in that podcast episode. It's on the channel if you search for Drake or for Kendrick. But I will get back to Drake's lawsuit if we want to just see if there are any points made or if we just want to giggle together. Like, we can do that. We can't do that today because we have to get back to like Massachusetts law things. So let me just roll the intro. I've got coffee. Let me know where you're coming in from, what you're drinking. It's I've got coffee. I made a cappuccino. It's look, coffee plus Dayquil. An hour in, I'm gonna be like, who doesn't feel good? Not this girl. We feel great. Everything is awesome. All right, law nerds, let's roll the intro. Thank you for letting me know what you're drinking. Cassie said the entire stadium singing A minor. If you guys don't follow Duolingo on social media, Duolingo's like, we have music. Duolingo has memes of a bunch of Duolingo animals singing A minor on their shady ass social media presence is something that I live for. It's hilarious. All right, let's get started.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
I mean, me. This is where the law nerds talk about facts. Also me. Let's talk about internet fuckery. Let's talk. Look, man, if you are going to take shots at someone like Kendrick Lamar, it's not like Drake didn't know what he was going to get. What did you think was going to happen? The level of, it was so good. It was so good. We'll get into the murder mystery of Duolingo soon. We might need to have a whole episode. You know how I love a social media cleverness. I was here for it with Dunkin' Donuts. I'm here for it now. I don't need to be sponsored. I love the social media presence and I'll talk about it. It's funny. So we will get into Duo. We have to get to the Supreme Judicial Court today. So let's talk about what we're going to do today. First, the Supreme Judicial Court opinion. Thank you for no spoilers. I have not read through the entire 35-page opinion. I was like, oh no, law nerds. Generally, they give an indication of what their ruling is at the beginning, so we should know soon. Then we're going to get into Trooper Proctor updates. Then we're going to get into the new defense filings and the updated scheduling order. There will be more filings today. I am not covering them today. I am going to cover them either tomorrow or the next day. But there will be more filings today because today is a filing deadline. So there will be more to happen. It's just not happening for us on this stream. Just to set that expectation out there. And then maybe we can talk about Duolingo. If we get to it. I think starting with the Supreme Judicial Court makes the most sense. So let me swoop and let's give a quick road so far. For those of you that did not watch the Supreme Judicial Court with me, that is A, totally fine. B, it's on the channel if you want to see it. But C, I'm going to give you an update now so you know what we're looking at and for. So Karen Reed and her attorneys and the Commonwealth, through their attorney, no, not Lally, no, not Brennan, their appellate attorney, argued to the Supreme Judicial Court. The defense had made motions that were legally difficult at best to dismiss the counts of Karen Reed's case they say that the jury came to verdicts on. I understand where they are coming from when numerous jurors reached out and said, hey, we had verdicts on two of the most serious counts, counts 1 and counts 3. We had verdicts. But then we came into court and we couldn't resolve the second count, and then it just got dismissed and we just got put back on a bus and we had no idea WTF is even happening, but we had verdicts on 2 of the counts. And the argument is, legally, are those final verdicts if they are not written down? Like, is that your final answer? Like, when you say deal or no deal, is it final till you like hit the button? So if it's not written down, is it a final verdict? And I find this entire circumstance deeply frustrating because it remains my position that had the jury just been polled, this would have been resolved in the courtroom before the jury was dismissed. I believe the jurors that said this all happened really fast. However, I have been told by many that it is not the common practice to poll juries in Massachusetts. And it is true that neither side asked for the jury to be polled and had the opportunity to do so. So there are some legal nuances here that are difficult because at where we stand now, I don't love at all that the jury wasn't polled. Can't go back and do that. Can't unring that bell. And I also don't love that they didn't hear from the jurors, which we have seen in case after case in different jurisdictions, where they brought the jury back in and was like, tell me more. Tell me more. And I wanted to hear from the rest of these jurors because 3 jurors saying something doesn't make it true. I wanted to hear from all 12 jurors. I thought that was an unrealistic ask, but I wanted it anyway. Sometimes we don't get what we want, you know, in the words of the Rolling Stones. What I find frustrating is someone who worked in criminal law for quite a while and who's been an attorney for almost 20 years. The thing I like the least about all of this is that when jurors feel like they have done their civic duty and then feel that the process did not work properly, it not only leaves an incredibly bad taste in their mouth, but also for everyone who interacts with them. It's a really, really bad experience. Because if you are sitting there for 10 weeks and you come to not guilty verdicts on 2 counts, and then they're going to retry that defendant on those 2 counts, it does not feel like a just result to anyone. And that's really frustrating. So I feel for these jurors. I wanted to see them polled. I knew that that probably wasn't going to happen at the trial level court. We'll see what happens with the Supreme Court. However, this motion was always an uphill battle. And the defense brought the motion under a, can we please do this? But there wasn't really a good process in the law to allow for the remedy that the defense was asking for. And it's different than Murdaugh. And we'll talk about it again, I'm sure. It's different than Murdaugh because in the Murdaugh case, it was an external person alleged to have influenced the jury. And that's all still being appealed. And there are times that jurors are allowed to be asked after jury service about their jury service in that circumstance and in just the other narrow circumstance about bias, etc. There are these very narrow issues where a jury can be asked. The rest of the rule is you cannot inquire into the jury's deliberative process. That is the rule. That is a hard and fast rule. That is a cornerstone rule. Thou, like none shall pass. Thou shalt not inquire. And the nuanced question that came up here is asking the jurors about whether or not they reached verdicts, asking about their deliberative process, or can those two things be separated? Can you separate out, did you reach a verdict, from the next logical question, then why didn't it go on the form? Because it has to be a final verdict. So it is, the defense has always been in a difficult position going into this, but we will see. So let's go to the Supreme Judicial Court of Massachusetts to their ruling. It is 35 pages long of a slip opinion. So if it looks like it was done on a typewriter, yes. It does look like it was done on a typewriter. Is this the final word from the Supreme Judicial Court? Yes. This is your final opinion. Let me make sure that gets added. All right. I'm going to try to embiggen this so we can read along together. No, I think that was better. All right, let's see. Oh, that's not the right screen, Emily. All right, give me 1 second to share the proper screen. Emily, you can't have this open in multiple tabs. It's just going to screw everything up. There you go. It's like you've never streamed before. Every time's like the first time. Look, streaming is dynamic. Streaming is dynamic. Karen Reed versus the Commonwealth. Let us go. This is November 6, 2024 to February 11th, 2025. Today being February 11th. Supreme Judicial Court. These are the charges: homicide, motor vehicle, homicide, operating under the influence, leaving the scene of an accident. And then these are all the other tags up at the top. I told you guys it was going to look like it was made on a typewriter. We've got the civil action commenced in the Supreme Judicial Court September 11th, 2024. The attorneys that popped in, the amicus, and the decision written by J. George, yes, that. The defendant challenges the denial of her motion to dismiss after her first trial ended in a mistrial, footnote 1. That trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses. God, it looks bad in writing. And 657 exhibits. Emily, was there any need for 74 witnesses? No. No, there wasn't. This is not a complex multinational, like, money laundering ring. There was no need for 74 witnesses. The defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges, which would preclude a retrial. This is being addressed on a different issue. Instead, her argument focuses on whether the trial judge properly declared a mistrial and the relevance, if any, there's the first what if any, of post-trial accounts of jury deliberations. Yikes. Yikes. There's not enough coffee for this today. Why do I say yikes? Because they didn't say jury verdict. They said jury deliberations. And if the court thinks that the question about whether or not they reached a verdict is deliberative, then the answer is going to be no. You cannot inquire into deliberations. If they think this is deliberations, the answer will be no. Let's look at the footnotes after we finish this sentence. At least it's double spaced. The jury deliberated for 5 days, sending progressively insistent notes to the judge about their inability to reach a unanimous verdict. In their third and final note, the jury stated that, quote, some members firmly believed that the evidence surpasses the burden of proof establishing the elements of the charges, while others did not. Which charges is the difficulty? They described their views as rooted in sincere adherence to their individual principles and moral convictions, and stated that further deliberations would be futile and would force them to compromise these deeply held beliefs. Based on this final note, the judge declared a mistrial. Let's look at the footnotes. Footnote 1. Although Karen Reed commenced this action by filing a petition in the county court, for convenience, we refer to her as defendant. Okay, fine, because she is the defendant. They go on to say, the record submitted to the single justice and now before this court does not contain transcripts of the testimony or exhibits from the defendant's first trial. Interesting to note. However, they are not appealing a conviction. There was no conviction. They are asking a very narrow question about whether or not it's essentially double jeopardy to try Karen Reed on counts 1 and 3 if the jury reached verdicts. So they don't need the entire trial because that's not the question before them. They go on to say the defendant's motion to dismiss and this petition rely on post-trial accounts from several jurors. These accounts suggest that during deliberations, the jury unanimously agreed the defendant was not guilty on 2 of the 3 charges and were deadlocked on only the remaining charge. The defendant argues that a mistrial was thus not manifestly necessary. That's what the law says. Because the judge could have requested a partial verdict from the jury before discharging them. Here's the question. Does anything in that note indicate, we got to put our feelings aside on this one and ask the question as an intellectual exploration. Does anything in that last note indicate that they have a split verdict? Anything at all? And that is part of the problem here, is that the note does not say we've reached a split verdict. And that's incredibly frustrating because all of us, I think, let me know if it's not. I think a lot of the law nerds just wanted the jury to be polled. All of us are like, just poll the jury. But hindsight is 2020. And that note doesn't seem to indicate that there's any confusion. That note is any further deliberation would be futile and force us to compromise deeply held beliefs. Frustrating. But doesn't indicate a split verdict at all. There's no way to know. There's no way to know. The defendant's motion to dismiss and this petition rely on post-trial accounts from several jurors. These accounts suggest that during deliberations, there's that word again, the jury unanimously agreed the defendant was not guilty on 2 of the 3 charges and were deadlocked only on the remaining charge. The defendant argues that the mistrial was thus not manifestly necessary. The defendant further asserts that these post-trial accounts show she was, in effect, acquitted of 2 charges, and that double jeopardy bars retrial on those counts. This petition thus raises the question, God, the legal writing at this level of court is just so fucking good. It's just so good. It's just so good. This is what I'm raving about. This is the excellence. A, it's clear and concise. I'm a big fan of the keep it simple. Clear and concise. Then they lay out how we got here really quickly. How did we get here? Then they distill the question into one question and make that clear and concise. Because the thing is, and you will notice this is one of the beginning of law school things, is that if everyone's talking about a different question, you're never going to come to an answer. And time is well spent defining the question so that you can endeavor to find the answer. If you do not understand the question, you can never really endeavor to find the answer. This petition thus raises the question. My family also hates it when I do this, but they're getting used to it. With all the different neurospicy in my household, they're getting used to it. But when someone starts with a thing, I'm like, what is it that you are asking me? Tell me first what you're asking me and then give me all the information. Because if you're just telling me something to tell me, that's great. I have a different process. If you're telling something because you need me to solve a problem, then I know that I'm trying to ask you information to solve the problem, and I'll interrupt you and ask the information I need to solve the problem. If you got a problem, I'll solve it. If you very urgently need an answer, then say, I need an answer. Great. But if you're just like sharing, also great. But then I won't interrupt the fuck out of you trying to figure out what the question is. Just sharing is fine. Anyway, we'll continue on. I love it when the question is defined at the beginning. It's the way my brain works. It's the way my brain works. And if someone talking to me wants me to not interrupt them, which is difficult for me on a good day, if I know that you just want to tell me, like I want to share, then I'm not trying to find all the information my brain might need. If you want me to decide where to go to dinner, then we got questions. This petition, can they make a carajillo is the question lately. This petition thus raises the question, can post-trial accounts of jurors' private deliberations, damn, they say that word again. The amount they keep saying deliberations causes me concern because they are not saying verdict. They are not saying verdict. They are saying deliberations. And what did we say about deliberations? None shall pass. Oh, they're going to say it in another sentence. Emily, keep reading. Can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record the verdict in open court? We conclude they cannot, and that's the answer. We conclude they cannot. Well, whoop, there it is. So they framed the question incredibly well, and we saw them talking about deliberations multiple times, which kind of signaled the way that this was going to go. But that's the answer from the Supreme Judicial Court. We're going to go through 35 pages of law, but that is the answer. The answer is no, this cannot. Bupsy says, begetting legal memoranda with the question presented orients the reader. I agree with it. I think it's the way all conversation should happen. I need to be oriented to what we are doing. Start with the question and then give me the information. It's the way my brain works. Probably why law school felt comfortable for me. Can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in open court? We conclude that they cannot. That was always going to be the most likely outcome. I was optimistic that one of these courts would say, we should just ask them. We should just ask them. I think you can parse between, and again, my knowledge of the legal history of Massachusetts is not deep. I am not in their Supreme Court. Their legal traditions are different than other legal traditions. We have watched other courts in other jurisdictions ask jurors questions, but we have never seen them ask questions about the deliberative process, and we have never seen them ask questions about whether or not they rendered a verdict when they did not say that to the court. And it is a very nuanced and difficult situation. The hard thing about it is it feels frustrating. Because if jurors are saying, I sat here for like 10 weeks with jury selection and we came to verdicts, not letting those verdicts bear out is frustrating. I'm interested to see if any of the jurors come forward and ever talk about this. Maybe after our next trial, maybe down the road. But I imagine for these jurors, this has to be incredibly frustrating. Not to mention how frustrating it would be for Karen Reed and her legal team. But let's go through the legal tradition and see how we get here, because if there's something a Supreme Court's going to do, it's going to give us all of the law of how they got here, because this keeps in line with their prior rulings. This is a very discrete and nuanced situation. I've seen a number of you already ask, is this going to change the law? Is this going to change the law in Massachusetts? Does this change anything? This is in keeping with their legal tradition. So this is a very unique issue. What it might change is that we may see the defense bar in Massachusetts asking for juries to be polled every single trial. That it might change the practice of law and the habit of the attorneys working there. That's where I see this changing. And oftentimes, as things are shifting in a legal community, you will see the defense bar shift. And sometimes you'll even see the prosecutors shift. Like, you'll see prosecutors, there was a period of time when marijuana was kind of up in the air. It was always in the air in California, Emily. But the marijuana rules were kind of up in the air. So a lot of the district attorney's offices stopped prosecuting things like simple possession and stuff like that. So you can see, even if the law is shifting, you can see policy decisions made, and you can see the way attorneys practice law shift a little bit. And so you'll see things like that in changing areas of law. And then with the defense bar, I think you will see those habits change here, with defense lawyers saying, no, we want the jury polled. We're going to see this in Idaho too. We've already seen it play out a little bit, where you're starting to see motions being made in Idaho fairly regularly with regard to the proper standard for a grand jury. And it's going to push eventually to court, where court rules on another case and lines it out even more specifically. And then you have other precedents. So let us continue on. The jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. This is why this situation is so fucking frustrating and incredibly unique. Because of the way things were worded, and I don't think anyone anticipated this situation coming up, because of the way things were worded, charges could be count 2, and charges could be count 1, 2, and 3. And so, hold on. Kathy, I think this is legally the proper result, though the frustrating result. We're going to go through the law. I wanted to grab Katie Jean's question so I can get to it. You guys have great questions in the chat. Just so you know, if I stutter, it's because I'm processing the questions as well, because you guys have amazing questions and I want to hold them as we get through into some of the law. So yes, I'm grabbing them. Only after being discharged did some individual jurors communicate a different supposed outcome. Oh, okay. Contradicting their prior notes. And that's the thing. The notes were very clear. But it doesn't mean that all the jurors agreed with them. And that is an issue of deliberation. And that's something you can't ask the jurors about. Could the jurors come forward and speak about it? Yes, they can. Yes, they can. But a court can't ask. A court can't ask, did you feel pressured to go along with this note? Did you know this note was being sent? All of those things cannot lawfully be asked by a court. I know that might feel weird. It might be like, what the fuck? I know. But that is the law. You cannot ask jurors about their deliberations at all. So asking them anything about the conversation between them is a no-fly zone. Again, if you go back and look at my coverage on this, I was like, but I see a hair that we can split here. Maybe we can just split a hair because I wanted this. Not Massachusetts doesn't think this is lawfully the correct result. It is the result that I wanted. I wanted to see the jury polled. I think it gives the jury decision dignity. I think it accommodates for their time. I think if there is even a consideration that they were not able to properly fill out the forms because they were confused because of the language of the jury instructions, that you ask them. That's how I feel. It's my feelings. Does that mean it's lawfully correct? No. I was hoping they would split the hair and get there. I don't think they're legally wrong not getting there. And that's frustrating too. All right. The notes were so clear. The notes were so clear and direct, and that's part of the problem. Such post-trial disclosures cannot retroactively alter the trial's outcome, either to acquit or to convict. Also, this unique circumstance would only work in the favor of the defendant. We wouldn't even get here if the jurors were like, I thought we convicted them on one count. It would be like, nope, we're not even, nobody's talking about it because that's not happening. But when you look at the law and look at how clear it would be that after a mistrial is declared, you can't go back and convict someone, the result should be the same both ways. However, the defense made the argument that double jeopardy forestalls that, and if a jury reaches a verdict, that should be honored. If it's an acquittal, if it's a not guilty, because then double jeopardy comes in here. And that's difficult. So accordingly, they say we affirm the trial judge's denial of the motion to dismiss and the defendant's request for post-trial juror inquiry. And that is the result. Footnote 3. The motion filed by the American Civil Liberties Union of Massachusetts, Inc., seeking leave to file an amicus curiae brief is hereby allowed. Like, we've got your brief. Nothing's going to happen from it, but we've got your brief. If anything, and we're going to go through the law, Emily, if you soliloquy every sentence, we're never going to get through this. It is 35 pages long. Girl, I know. I hope that this being brought up and the fact that it has been widely covered and discussed empowers future jurors to speak up. I'm here to tell you it's okay to be the pain in the ass juror. It can be really uncomfortable, but it's okay to be the pain in the ass juror. It's okay to say, can we ask the judge? Can we ask the judge? Sometimes there's nothing the judge can do. If you ask a judge, does this mean this? Sometimes they can answer, sometimes they can't. Because sometimes it's what the juror needs to decide. If a judge ever comes back with an answer that says you have all the evidence before you, it means the question being asked is a question that goes to a decision the jury has to make. You have all the evidence before you. And if you are a juror and you are confused, you can ask. So I hope that the populace of all y'all, except for the international law nerds, hey, international law nerds, your systems are different. But for those of you serving jury duty in this way, you know that you can ask. Law Nerd Junkie said, but what if the foreperson says no to asking the judge? It depends on the jurisdiction, but generally there is not a clerk of court, Becky. Generally, there is a bailiff assigned to the jury. You can ask the bailiff, we have a question for the judge, and write the question down. Generally, it's only the foreperson, but you can still ask. Look, you don't ask, you don't get. You can ask the bailiff. And, if you are the jury and you are out in court and the judge is doing a thing, you can raise your hand and say, Your Honor, we have a question. I have a question. Who hesitated doing that in class? Some of us did, some of us didn't. Go all Hermione on that shit. I got a question. Judge, you can ask. And I don't think they knew that they could. And I think the language of the jury instructions was incredibly fucking confusing. And I was nervous. In closing arguments. And if you go back and watch the closing arguments, I was nervous in the closing arguments. I said I wanted to see the attorneys of either side take some time to go through the jury instructions and explain them because they were confusing. And none of the attorneys, it really should have been the Commonwealth, but if the Commonwealth didn't do it, the defense kind of had to. None of the attorneys went through the jury instructions and said, this is what this means. This is how you find this. And it is one of the biggest mistakes I see attorneys make in cases, especially prosecutors. It is not the defense's job to make it more clear to convict their client. That's not their job. That's the opposite of their job. So if the jury instructions are confusing AF, it, I think, is a benefit to the defense to not explain that shit at all. And if you are the prosecutor, and sometimes, look, some of you might be new. Some of you may already know this about me. Sometimes I think the way I do it is right because it worked well for me. Does that mean it's right for everybody? No. Clearly, my spouse thinks loading the dishwasher not the right way is the right way in his brain. I mean, it doesn't work if the bowl's face backwards, but we've been married over 22 years and we'll sort it out. I just load the bowls because I want it done my way. But I firmly believe that this process of closing argument is better, and I am right. On this, I am right. Like, objectively correct. If you are the prosecutor, you have to at least explain to the jury what the elements of the jury instructions mean. You have to tell them these are the different elements. You have to decide each of these things. And when there is a confusing as fuck verdict form that has a whole bunch of alternate charges, put that shit on an Elmo or a PowerPoint and go through it and tell them, this is how you find a verdict. And if that verdict is guilty or not guilty, the goal is to let the jury decide. Look, I didn't know this was going to be a soapbox. Here the fuck we are. The goal is to let the jury decide. Show them the evidence and let them decide. If the evidence does not meet what you charge, then not guilty is the only result. If the evidence meets what you charge, then guilty is the result. But if the jury does not know how to answer those questions and you did not tell them how to answer the questions, then a hung jury is very likely the result because they're all sitting back there going, I don't know what this fucking means. Maybe this, maybe that. I don't know. Nobody told us what to do. Nobody told us how to fill this out. I went through the verdict forms, and the verdict forms as to count 2 were confusing. The jury instructions as to the lesser included were confusing. I had a judge just absolutely ream me after a trial. Oh, story time. Emily, are you stalling until your Dayquil kicks in? No, story time. Story time. The jury instructions on the charges that I was prosecuting were, I thought, very badly written. The law in this area was confusing. It has since improved. The jury instructions were confusing. And so as I was going through at that time, my giant paper Post-it note that I would write on because it felt more human, and I didn't always have time to put things up on an Elmo and print them out because at that time the court was not allowing you to plug into anything. Emily, you said you've been practicing law for 20 years. Yes. So I would write them out by hand and I would tell the jurors, look, I am dyslexic. So if I spell this wrong or write it backwards, you have them in front of you, but just roll with me. You know what I mean. And I would go through the elements. And I said to the jury in my closing arguments, I find the elements of this confusing and written difficultly. And then I took a shot at the legislature and was like, look, the legislature writes all of this. And, I don't think they think about all of us sitting here doing this. And it's incredibly confusing. So I understand. So we're going to go through it together. The judge called all of my supervisors. If you've seen the movie Office Space, you know what it's like to have 900 supervisors. All of my supervisors at the courthouse, 3 of them, to talk about how wildly inappropriate it was that not only did I say dude in my closing argument to address the jury, which I did. It's gender neutral, Your Honor. Dudes of the jury, which is not what I said. I did not say dudes of the jury. I did say dude at one point, though. And that I denigrated the esteem of our legislature by discussing how poorly written the kidnapping law was. This judge and I did not get along at all. Some of you in member space, this is for members. I've talked about this judge. You guys know I keep an eye on this judge. Denigrated the legislature. The legislature had no idea how to write a law, and this case made me furious. This case made me so fucking mad. And so by the time we got to closing, I was pissed. Just pissed. And the law was confusing. It was a terrifying case. The victim had been through all sorts of shit. The defendant's family was being awful to the victim. I was so mad. So when I was trying to describe why this awful thing happened to this victim and how confusing the law is to apply, I was pissed. My supervisors said, does Emily hold a grudge? Yeah, me and Kendrick Lamar, Southern California. When I am wronged, I can't let all of it go. But there was a lot. This judge and I, there was a lot. My supervisors were like, you know how she is. And I said, yeah, I do know how she is, but I'm not going to change how I am. And so you can either move me into a different courtroom or know that at some point she is going to find me and y'all are going to have to pay it because I'm not wrong and I'm not backing down. And I'm fucking pissed. Do not kidnap my victim at knife point when she's trying to get home from work. That's all. Oh. Kate Manning said, Emily smiling to the camera, hey, judge. This judge, I did not get fined. This judge and I did not get along. Did not get along at all. She tried to make my life miserable. I eventually got moved out of her courtroom, which was the right result because she hated my ass. And at one point I walked into court and she's like, get her out of here. And I'm like, I have a case in here, Your Honor. She's like, no, you don't. I'm like, but I do. There was a day that she was making a ruling that was wild. And the defense attorney's like, Your Honor, we're not asking for that. Like when the defense attorneys are sticking up for you because the judge is wilding out, it's a wild day in court. But I had a good relationship. I had a good relationship with most of the defense attorneys I worked with. So Chiquita Banana said Emily's justice sensitivity has made an appearance. Yes, I get pissed. So we'll tell those stories later. Grace Bay says, so you know what it's like to be Alan Jackson. We worked in the same office together. Yes, we were both at the LADA's office, and LADA's can be feisty. We have a really big office and we have a lot of really good attorneys, and we can be feisty. And we can be feisty. Oh, Laura, we're going to have to talk. Lewin is on one. We'll talk about that another time. Not on the internet. This this judge, we'll get back into it in other members only, but there are some opinions about things that this judge has done, written opinions. Oh, this fucking judge. And she strongly preferred male attorneys in her court. And a lot of times the bosses would just acquiesce and things would go better. So, God, she hated my ass. It's all right. Everyone, steel sharpens steel. It makes you better. I had coaches that were tough, that didn't hate me, but were tough. I just kind of saw it that way. I was like, oh, this is like being hazed by a coach. Okay. I'm like, well, she's not going to kill me. Like, she can't actually shoot me in court. There were days, though, I was worried. I was like, she does have a gun under her bench. She might. She'd probably miss, though. So it'll be fine. I literally, there were days in water polo where I was like, I'm not actually going to die today, so it's going to be okay. There were days in court where I'm like, you can't kill me. You can't kill me. You can embarrass me. You can piss me off. You can yell at me. You can try to find me. I'm still right. Like, I'll go attorney Steele on that. You can find me. I'm still right. I'll stand in a cloak of righteousness and be pissed about it. I'm still right. But you actually probably can't kill me. So it's going to be fine. It's all going to be fine. Oh, that's not uncommon. Lexi, it's not uncommon. I imagine that things have shifted in that courthouse now, because the bailiffs don't want the judges taking things into their own hands. We had a judge who we would go to lunch with who would carry his concealed carry in a fanny pack. It was wild. Oh, the Taurus and EDB is strong. Yep. Look, man. All of my signs are Earth. Even my Chinese zodiac element is Earth. It's just all Earth. Taskin, I did not work with Josh Ritter, but we met, I think, at CrimeCon, but we did not work together. I plead the fifth. It was old courthouse. New courthouse was a little bit different. All right, y'all. Let's get back to this. I'm sorry for the soliloquy. We got on to one of my favorite / least favorite topics, and I just went wild. All right. Background. 35 pages. I love this. My longest grudge was 2 weeks. That's an Aquarius for you. My youngest is an Aquarius. But it's fine because my husband is a Taurus Scorpio. So my youngest being an Aquarius is incredibly helpful. I know. It's a wild combo. The Taurus Scorpio rising combo is fucking spicy. It's so spicy. It's so spicy. Background. Trial and deliberations. In 2022, a grand jury returned 3 indictments against the defendant. Murder in the second degree, count 1, manslaughter while operating a motor vehicle under the influence of alcohol, the infamous count 2, and leaving the scene of personal injury resulting in death, count 3. Emily, if you were going to try this case, no. But if I looked at all of the things at the beginning of this case, I don't know what the fuck made them think count 1 and count 3 were a good idea. I don't know if they've never investigated a motor vehicle accident before. I don't know. Y'all, I can see, well, before the first trial, I could see an argument for count 2. I could probably still make an argument for count 2, though after everything I've seen, I don't want to. Now that we've gotten past the first trial, but I think there's an argument for count 2. Especially in some of the lesser includeds. And I think they probably should have gone with the lesser included with you dropped him off and did not make sure he was okay. There's some in that realm, like due and circumscript caution. that could have been a misdemeanor. Count 1 is wild. I don't know how they decided to get there. Count 3 is also wild because I don't think they can prove that Karen Reed knew. And count 3 requires her knowing. I don't think they could have proven that. I still don't think they can prove that. How do you prove that? I don't think they did it. Like, I don't like it. I don't know how you prove count 1. And I don't like charging up to get the jury to come to a middle result when we're talking about a murder case. I don't like it at all. Sometimes DAs will overcharge things and then dismiss things before they go to trial. It depends on the jurisdiction. If you charge everything that's viable at the beginning and then narrow it down, I can see that. But they added count 1 and 3, and it's wild to me. Brienne said her voicemails sure don't sound like she knew. I agree with you. I agree with you. So, yeah. I don't know how they added those counts. I don't know what they were thinking. I still don't know. We'll see what Brennan thinks. I couldn't follow Lally at all. I don't like it. And I know there will be some that say, oh, Emily, it sounds like you're just this, that. Maybe, but also after watching the first trial, my focus on this case is what did the Commonwealth prove? So my statements are all based on what did the Commonwealth prove to me? Not what the defense said, not what else could have happened. What did the Commonwealth prove to me? And that is where I'm basing all of this on. There is so much else going on in this case, but my focus remains, what did the Commonwealth prove? And I'm still not sure that it was snowing. I'm teasing. I know it was fucking snowing. I know it was. Before deliberations began, the judge indicated that the foreperson for the jury would be given separate verdict slips for each of the 3 indictments. The judge then explained the procedure for delivering the verdicts. I'm going to read this carefully. More coffee. My throat doesn't hurt, which means my Dayquil's kicked in. No, Emily, you just full-throatedly read a judge that you didn't like on the internet. It was fine. You feel better. All right. Finish the coffee. Read the judge. All right. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge. Then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. And again, the jury does not have this written in front of them. They just have to rely on what they heard the judge say, like a freaking game of telephone. But this is the problem. The judge also instructed the jury to continue deliberating until you have reached a final verdict on each charge. That is not the judge's soliloquy. That is in the model jury instructions. Will Massachusetts shift their model jury instructions? Maybe, maybe not. That's up to them. But this is not the judge wilding out. I know a lot of you do not have fond feelings for this judge. I understand. Your feelings are your feelings. You are entitled to them. The excessive sighing makes it feel like she just doesn't want to be there. But this is not her language. This is the model jury instruction, and it's confusing. Because I think a lot of reasonable minds would look at that and say, continue deliberating until you have reached a final verdict on each charge. I think a lot of people would interpret that as until you have reached a verdict on every single thing, you don't come back to this court. I think that is a reasonable interpretation. It goes on to say, do not disclose the numerical standing or progress to anyone, including the judge. That does not open the door for jurors to say, hey, Your Honor, we've reached some but not all. That seems to literally close the door to having a conversation. Do not disclose the numerical standing or progress to anyone, including the judge, before such time as you have reached a unanimous verdict. I think that's confusing. And I think that is where if you have literal interpretations and you are going off of what you heard the judge say, they don't have this written in front of them. They can't pick apart the verbiage of this. They are listening in and then going back and saying, okay, she said keep deliberating. Because I don't think they have a copy of the jury instructions. Maybe they do when they're deliberating. I don't know if they take them or not. But it makes it harder to parse when you're just trying to explain something you've never seen before and understand it. Don't disclose the numerical standing before you have reached a unanimous verdict. The jury began deliberations 3 days later. God, this jury kept me jumping. Laura said, so you can't approach the judge unless you're anonymous. That's how it reads. But in different jurisdictions, jurors do it all the time. But that's how it reads to me. So I could see where the jury would read that saying, we can't ask questions. Different jurisdictions have different kind of histories with how they write their jury instructions. So jury instructions read differently across different jurisdictions, but there are model jury instructions. Sometimes you'll hear them referred to as the MUJIs or the UGs, the Model Uniform Jury Instructions, MUJI. And they have a foundational base, and then different jurisdictions modify them. They have committees. For those of you that watch Peter at Lawyer You Know, he talks about being on some of these committees where they work on modifying, updating, writing jury instructions. One of my friends who is a judge just had a trial regarding some newer laws, and there aren't jury instructions for them yet. So they had to write with the attorneys, judge and attorneys, write the jury instructions to line out what the elements are on revenge porn, because it's a newer law that doesn't yet have model jury instructions. So some of the model and jury instructions are well trodden, some of them are not. Leon, congratulations. And then different committees, if we're going full behind baseball, different committees have different feelings on how they want things to bear out. And there are definitely jurisdictions that are like, we don't want split verdicts. We do not want a split verdict. Reach a fucking verdict. Just reach a verdict. And so the jury instructions, if you read them with the perspective of, does this jurisdiction favor or disfavor split verdicts, you can see the lean in Massachusetts that I think disfavors split verdicts. Kelly Sue, I did say revenge porn because California. So I did. But there aren't model jury instructions for it yet because not every jurisdiction even has laws for it yet. So when you read these jury instructions, I read these from the perspective, again, I did not practice in Massachusetts, but the vibe is we do not want split verdicts. Come to a decision. And whatever that decision is, we don't want some of these counts straggling along. Reach a verdict. Because they don't want to do it again. And this was all going down during VidCon last year. God, my travel streams these days were not always good. Jenny, very generally on that, the non-consensual sharing of personal or intimate photos and or videos. I covered it. If you're actually interested in a more in-depth discussion of like laws covering modern problems that didn't used to be a problem. Like, draw me like one of your French girls, Jack, is not the issue here, but cameras can be hidden. Modern technology opens the door to problems that didn't used to be problems. And I covered it in the Sandoval case. So if you're curious, I covered that in the Sandoval case. But sometimes you don't have jury instructions for the thing and you have to write them on the fly. It's difficult. All right. 3 days later, for those of you that are like, Emily, I'm lost with your ADHD of it all, don't worry. It'll be on Quick Bits tomorrow. Our editors are brilliant. And there will be a summary. So do not worry, I got you. 3 days later, after approximately 19 hours of deliberation, the foreperson submitted a note to the judge. First note. This is interesting to go through because these notes matter significantly. Remember, the notes matter significantly, and you cannot ask the jurors, why did you submit this note? That is kind of a key thing to remember in all of this. You can't ask them why. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. It does not say we have reached some verdicts. It does not say we are unable to reach a unanimous verdict on all counts. It does not indicate anything other than we have been unable to reach a unanimous verdict. I'm going to pronounce this badly. MST 3K Harris. I can get the last part. I can't make the other part work. Why can't you ask the jury why? The law is very clear that you cannot inquire into jury deliberations, and that is a part of the law that is not going to change. It is cornerstone to our jury system that you cannot inquire into deliberations. There are very, very, very limited circumstances where you can ask jurors questions. Outside influence is one of those very limited circumstances. Outside influence, like Courthouse Becky in the Murdaugh case. Because you're allowed to ask what the outside person said, and then the only question you can ask after that is, did that impact you? You can't say, what did you say about it? What did other people talk about it? Did it impact you? But you can say, what did the outside person say to you? Outside influence is a very narrow exception. There's no exception for this. So that's the first note. And then they're going to go through the whole circumstance, which you can read or you can watch. We went through it. When they made this motion, we went back and rewatched it. Oh, of course, if you ask the question, I figured that there are others watching that also have the question, but their hands are busy folding laundry and they did not type it into the chat. So I assumed that others have the question, so I got it. All right. After reading the note into the record, the judge requested argument from the parties on whether the jury had conducted, quote, due and thorough deliberations, warranting a so-called Tui Rodriguez charge. It's not so-called. That's what it's called. It's a Tui Rodriguez charge. That's what it is. Footnote 4. See Commonwealth versus Rodriguez, Commonwealth versus Tui. The Tui Rodriguez charge is a model instruction, quote, given when jurors report deadlock after, quote, due and thorough deliberation. This is, quote, designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. See Commonwealth versus Carnes. Once a deadlock jury receives the Tui Rodriguez charge and resumes their deliberation, quote, they shall not be sent out again without their own consent. None shall pass. Heather Ruth says, I feel called out. I have unfolded laundry on my bed. You're not called out. It's supportive. Also, sometimes you need a visual system for your clothing. and the bed is a good visual system. Also, when you are ADHD and other neurospiciness, sometimes you need like a rotating system of like clean, like will wear again, but I can't put it away because it's not specifically clean, but it's not actually dirty and I don't want to have to wash it yet, but I am going to wear it again, but it's not clean, so I can't put it away, so I still need it somewhere. That needs a category on its own. And then like I need to wash it, but for some reason I can't wash it yet, needs a category. Like other shit needs to happen before I can wash it. Stain, need to cut something, need to wait till I have others of that clothes, whatever. And then there's like the dirty. It's like a 4-part system at minimum. Sometimes it's just like, no, I need to wait until I have enough socks so I can just wash them together. I got you. Yeah, the chair category, exactly. I got you. It's a system. And however the system works for you, work with it. Don't be embarrassed. Also, make sure you can just close the door so nobody needs to know. It's fine. It's just between us. And I've taught my kids to embrace the system instead of just fighting with them. We just embrace the system. And then we modify the system because cats. And I do have strong feelings about being covered in cat hair when I'm not in my house. So there is also like I'm wearing this at home because my cat will be on me. So also that. It just is. We work with it. All right. As long as they know where the clean clothes are, we're good. As long as they know where the cat clothes are, they're good. The Commonwealth argued that the jury had not deliberated long enough, while the defendant disagreed. Which also was interesting, because I think the Commonwealth was like, if they just go back, they're going to come to a verdict. And I think the defense was like, cut our losses now. Requesting the instruction and asserting that the foreperson's use of the word exhaustive suggested an impasse. So the defense wanted this jury to hang faster. Stacey L, no, the chat will start sharing their systems with you. You are not alone. You are not alone. You are not alone. The defense was ready for the Tui Rodriguez charge after 19 hours. The defense is like, a hang is a win because they get to do it again. So the defense would rather have this jury come back without a verdict than come back with a guilty verdict, 10-10. So they're like, nope, let's do this. They go on to say the judge determined that further deliberation was appropriate. There were 74 fucking witnesses. The closing arguments from the Commonwealth were so confusing that I'm not surprised the jury was like, what? They go on to say deliberations extended through the afternoon and resumed the following morning. At 10:45 a.m., the jury foreperson submitted another note to the judge, second note, which said, quote, despite our commitment to the duty entrusted to us, it's a very dramatic note. Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. There is nothing in this note that gives indication that this jury was decided on some counts. They say the divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point where consensus is unattainable. And I understand this. Think about where you were at the end of this trial, for those of you that watched. Wherever you stood on this view, is someone going to convince you otherwise at the end of this trial? If somebody came to you and was like, yeah, but this, yeah, but that. If you had made up your mind at the end of this trial, you're not going to be swayed. If you're sitting there going, the Commonwealth did not prove to me that she knew, I'm not voting guilty on anything. It's not fucking happening. There's no way you're changing your mind. And if you're sitting there at the end of the evidence going, she was involved in John O'Keefe's death, and you're not going to convince me otherwise, I am convinced on second degree, you're not changing my mind. I understand on this case how jurors are like, you're not making me change my mind. It's a consequential case and it is not clear. And I don't think that the Commonwealth made it clear. So I get it. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. We know that this is going to hang. Hold on. What does Dr. B need? Dr. B, what do we need? Hold on. Okay. Can chat give me 3 seconds? My husband is trying to pick up something for my kiddo's birthday and is like, I need you to forward this to me. Chat, I'm not leaving you, but I am here. But we are going to take just a real moment while streaming is dynamic, while I send this to my husband real quick. I apologize. And I apologize. But also, Dr. B is getting it done. And I need to pull this up real quick. So thank you, chat, for hanging with me. Just hold on. Where's our music bed? Where's our music bed as we just take a moment? Why won't my mail open? Come on, mail. Good Lord. Everything's harder when you're being watched. Don't you know that? Just open. Did my computer update while I was gone? I think it did. All right. For those of you that my kiddo is obsessed right now with Civ, and new Civ came out. And okay. So I need to send him a game confirmation because he's picking up a pre-order situation for my youngest. I love that he's obsessed with Civ, by the way. It's so much fun to watch. Let's see. Sending. All right. And let me send him this one. Thanks, chat. We'll music bed one more time. For those of you asking, what is Civ? Civilization. They're releasing a new one. It is a turn-taking game that melds history, but is digital. And it is fantastic. Yes, Sid Meier's Civ. I played Civ in college. The joy I have that my neurospicy kiddo is obsessed with Civ because it brings in history and strategy and turn taking and hold on. And there was a pre-order gift situation. So I am forwarding Dr. B the emails from the pre-order situation so he can pick up the pre-order gift that came with it for my kiddo. So Civ 7 is what he's picking up real quick. All right. Let me just y'all are joining me for this. I'm streaming. You're on speaker.
Hello?
Hi, I'm streaming. You're on speaker. I sent it over. So we pre-ordered 2 games. So I sent you the
You're not coming in. Hold on.
I can hear you just fine, and so can the chat.
Yeah,
Can you hear me?
I can. I don't know why you're not coming through my phone. I had to put you on speaker.
Okay, we'll figure that out later. You're on speaker. I'm on live stream. I sent you over the confirmation and the shipping confirmations. We ordered 2 games.
Okay.
Okay?
I got it.
All right, thanks, B. Text me if you have a problem. I don't know why you can't hear me. Yes, so our youngest is turning 13. It's a whole different crisis. I can't talk about it. When my oldest had milestones, it was so exciting. When it's my youngest, it's different. I'm just like, So we ordered Civ 7 my youngest is absolutely obsessed with Civ, and you can play the game in different ways. There are different paths. You can advance in science or military or culture or whatever, and you can explore different ways of playing the game, whether you are a diplomatic or whether you just like stomp all over everything. It's wild. So, I know. I can't believe G's turning 13 either. I can't believe it. So, is he into Civ because I was? No. Well, yes and no. I bought Civ on the Switch for me, and it was not something he was ever interested in. He came across a YouTube video, because everything, with a content creator that he liked about, he had been watching about strategy in, I think, either Stardew Valley or Animal Crossing, and they were playing Civ. And with that, he was like, wait, do we have that game? I'm like, we do. And then he started exploring it, and it's been fantastic. Earlier on, his dyslexia was at a point where games that had a lot of reading would have been very difficult. And he is now at the place where he's like, I can understand what they're doing and engage in it better because I can read better. Like back in the day when he also plays Yu-Gi-Oh! Quite a lot. But back in the day when he was playing Yu-Gi-Oh!, we would read him the different Yu-Gi-Oh! Cards and he would memorize all of them. The kid is a brutal Yu-Gi-Oh! Player. I've seen him make adults sit down and go, wow. What? Okay, so let us continue. We're just back. We're just back. Oh yes, competitive Yu-Gi-Oh. Competitive Yu-Gi-Oh. It's a story for a different day. All right. Let's see. William said, Emily, surely for instruction form was not clear grounds for appeal. No, because it's the standard instruction grounds. So not clear grounds for appeal. But that's not why they appealed. Emily, I don't know. Well, maybe the chat will tell you if it's a hot take. Yu-Gi-Oh! I definitely think is a better card game. I like the dynamics better. Oh, Madam Jenkins, I know. All right. The note was very direct, right? Upon receiving this note, the judge again invited argument from both parties. The Commonwealth acknowledged that the jury had already deliberated in the vicinity of 22 or 23 hours. Right? But nonetheless argued it was premature to conclude their deliberations had been due and thorough. Yeah, jurors, Lally wanted you to be there for weeks, apparently. Defense counsel, however, maintained that the jury were hopelessly deadlocked and again requested the Tui Rodriguez instruction. The judge agreed with defense counsel, noting that the jury had been extraordinary and that she had never seen a note like this reporting to be at an impasse. I've never seen a note like that. It's wild. I've never seen a jury note like this. I have had very few jurors come back unable to reach a verdict. I've had jurors come back with split decisions. In every case I've had juries come back with split decisions, the note has generally said some version of what do we do if we reach a verdict on some counts? And then the response from the court is generally return a verdict on just those counts. But that is not what any of these notes said, and that is frustrating as well. Footnote 5. Although the transcript does not state the precise time that the deliberations resumed on Monday morning based on prior proceedings, it appears the jury had deliberated closer to 24 or 25 hours by this point. 25 hours of deliberation is a lot of deliberation. It's a lot of deliberation. The judge then delivered to the jury the Tui Rodriguez instruction, and the judge sent them back to deliberate further. At approximately 2:30 p.m., I remember this day. At approximately 2:30 p.m., the foreperson submitted yet another note to the judge, third note, which stated, Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find that the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. This deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. After receiving this third note, the judge informed counsel that the jury is at an impasse. Literally dead ass what she said. The jury were called back into the courtroom, and the third note was read out loud into the record upon reaching the final line stating further deliberations would force the jury to compromise these deeply held beliefs. The judge addressed the jury saying, "I'm not going to do that to you folks," and declared a mistrial. Didn't ask. "I'm not going to do that to you," and declared a mistrial. The judge then discharged the jury to the deliberation room, explaining that she would meet them there privately to thank them for their service, which is normal and typical in cases. That's not odd. The judge and the parties remained in the courtroom to discuss their availability for scheduling a status conference on the matter. At no point during this discussion did defense counsel object to the judge's declaration of a mistrial or express disagreement with the outcome. And I think that's a critical factor here too. The defense did not ask, "Can we poll the jury?" Because the notes were so clear. It wasn't until the jury started reaching out to the defense that they went, "Wait a second." And that's not their bad. Those notes are clear. Those notes are clear. I don't know what another judge would have done. Kim XOT in the chat asked, "Is she in jail?" No, she's been out of custody. She's been out on, I think she's out on bond. She might be out on own recognizance. She has been out of custody. And because the notes were very clear, they didn't know to ask. Like, you can't know what you don't know. Post-trial events. According to affidavits submitted by defense counsel, a member of the deliberating jury, Juror A, contacted defense counsel on July 2nd, 2024, after noticing inaccurate reports about the jury's alleged split that caused the mistrial the day before. Juror A stated that the jury had unanimously agreed that the defendant was not guilty of count 1 and count 3. That's the murder in the second degree and leaving the scene. 2 days after mistrial, defense counsel also received screenshots, footnote 6, of text message exchanges with jurors or their acquaintances describing the deliberations. Those are sketchier. In one exchange, another member of the jury, Juror B, wrote, "It was not guilty on second degree and split in half for the second charge," footnote 7. Footnote 6 is really a description of what a screenshot is. Courts are funny. A screenshot is a copy of the image displayed by a computer screen. Commonwealth versus Cornerin. Cornerin? Footnote 7, 1 month later, Juror B contacted defense counsel to confirm the content of this exchange. The way I'd be so pissed if somebody screenshotted a conversation that was between friends and sent it along to a lawyer involved in the case and it ended up in a filing. Don't screenshot people's shit and send it out unless you ask them. Like, what? People want to involve themselves in these cases. If the jurors want to talk to the lawyers, they can find their email addresses on the internet and email them, because those email addresses for their offices are public. Do not go to their homes. Do not try to find their cell phone numbers. Reach out to them at their offices. They have offices. In another exchange, an individual referred to as an informant was advised that another juror heard it from a friend who heard it from a friend who. Emily, you're sick. Why the fuck are you trying to sing? I don't know. Because it came out of my mouth before my brain could tell me no. A person who heard a person say a thing told the lawyers that their friend said, oh my God, my friend said that there was no consideration of murder in the second degree and that the jury was deadlocked on the remaining charges. The exchange contained no mention of count 3, but it stated that manslaughter started polling at 6-6, then ended up deadlocked at 4 no, 8 yes. Juror C also reportedly stated that the jurors had a group text going. Upon receiving this information, the informant commented, if they all agree on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge, which is not what the Supreme Court thinks, by the way. On July 8th, 1 week after the mistrial, the defendant filed a motion to dismiss. The way I was shooketh by this motion, I was like, what the fuck? The defendant filed a motion to dismiss based on these post-trial accounts. The defendant argued that the accounts showed that the retellings, the accounts showed that the jury had effectively acquitted her on counts 1 and 3. She further contended that the judge's mistrial declaration was improper for these 2 counts and requested at minimum a post-verdict inquiry to confirm whether the jury had agreed that she was not guilty of those charges. The reason they are pinning this on the mistrial declaration didn't need to happen is because that's really the only legal foothold they have to move forward in this request. Because you don't see the defense in the transcript saying, don't declare a mistrial. In fact, you see the defense in the recitation of timeline asking to declare the mistrial sooner. The defense doesn't say, don't declare a mistrial. It goes on to say she, and this is Karen Reed through her lawyers, further contended that the judge's mistrial declaration was improper for these 2 counts and requested the post-verdict inquiry. Defense counsel later supplemented the motion with accounts from 2 additional jurors. One juror, Juror E, did we switch? No, we didn't switch from letters to numbers. Stated that the jury had been deadlocked on only the lower charges on count 2. And the other juror, Juror D, stated that the jurors' disagreement solely concerned count 2 and its lesser offenses. Right. That makes sense. Because, well, if you're curious why I say that that makes sense, I covered the lesser includeds extensively. I covered the lesser offenses extensively. Juror D indicated that the jury had deliberated whether to inform the judge of their decision on counts 1 and 3, but they were uncertain if they were allowed to do so. This is discussing deliberations, and the court can't ask these questions. Juror D claimed that after discussing the matter, the jury ultimately decided to inform the court that they were deadlocked, and they expected that they would get further instructions about the remaining decided counts thereafter. Right. They did not communicate that they were deadlocked as to count 2. If any of those notes said count 2, it would be different. AVD, it's good to see you in the chat, friend. Hugs. I had the best time with you. Also, today my throat is being sketchy. It's like, you had too much fun. Your body must rest. If that note had said, we are deadlocked on count 2, at least they would have given a heads up that they were concerned. It does not say the charges. The Commonwealth also submitted a post-trial filing notifying the court that after the submission of defense counsel's affidavits, it had received 2 voicemail messages from a member of the jury. The juror specified that the jury had voted not guilty on counts 1 and 3, quote, and as of last vote, 9-3 guilty on the lower level manslaughter charges. The Commonwealth also received email messages from 3 individuals who identified themselves as jurors and asked to speak anonymously. Once the Commonwealth informed them that it may be required to disclose the substance of their communications to defense counsel or the court, the jurors declined to communicate further. The trial judge denied the defendant's motion to dismiss after a non-evidentiary hearing. The judge reasoned quote, because there was no open and public verdict affirmed in the open court rendered in this case, the defendant was not acquitted of any of the charges, and that any post-trial voir dire of the jurors would involve an impermissible inquiry into the substance of the jury's deliberations. This is the hair I think can be split. I think this hair can be split. I understand that is asking courts to go into a gray zone they don't want to go into. Courts don't want to do anything different. And asking the jurors if they reached verdicts gets very into the gray zone. They say, additionally, the judge's reaction, no. Additionally, the judge rejected the defendant's argument that declaring a mistrial was improper. She noted that defense counsel twice requested the Tui Rodriguez instruction, the final step preceding a mistrial. I don't disagree with the court on that. The court's not wrong on that. This is such a cluster of unclear communication. What we have here is a failure to communicate. Half the things in law, more than half the things in law. Because what we have here is a failure to communicate. There's so many ifs to this. If this, it goes differently. If that, it goes differently. If this other thing, it goes differently. If they were polled, it goes differently. Perhaps. If they had just said deadlocked on count 2 or a count, it goes differently. But the jury was so clear in their notes that it's really hard to unring that bell. And I can understand the court's hesitancy to open this back up again when the notes are not indicating in any way that they had reached verdicts on any counts. If the notes weren't this clear, could this have gone a different way? Maybe. But the defense might have asked for a poll if the notes had been less clear, and they didn't. The court concluded that in any event, a mistrial was manifestly necessary given the jury's repeated statements of a deadlock. On September 11th, 2024, the defendant filed a petition for relief under GLC 211, Section 3 in the county court. Footnote 8. Although a defendant is ordinarily not entitled to interlocutory review of the denial of a motion to dismiss, we have recognized a narrow exception to this general rule in the context of double jeopardy claims. The Commonwealth does not contest that interlocutory review is appropriate in the circumstances of this case. The court said in all of that, this is not normally the time when we would request or allow review. The only reason we're allowing review is because this is a narrow circumstance that involves double jeopardy and a pending retrial. And then they go on to say a single justice of this court reserved and reported the matter without decision to the full court. Footnote 9. And then they go on to the discussion. Now we have a choice to make. We are on page 13 of 35. They get into the legal discussion and we can go through it. I can link here. I'm going to put up a poll. Let me start a poll. We're going to decide. What? All right, what comes next? Quick. And next motion. All right, two options, chat. What comes next? A quick review of this and then the next motion we have from the defense? Or a full review of this and then bump the next motion till tomorrow? Because I am not going to be able to get through the rest of these pages And why won't this? No, get rid of that. So here's the poll. You guys let me know what you want to do, and we will do it, because I'm not going to get through all 35 pages, but I can put the link to the public document down below, and we can zoom through this and get on to the requests about the video. Or we can go through their full deliberative process if you want to. So I'm going to go a little bit longer, give you guys a few minutes on this poll, and then see if you're like, nah, we're over this, which is fine. But we're on page 13, and we're just getting to the discussion. Propriety of declaring a mistrial. The double jeopardy clause of the Fifth Amendment to the United States Constitution generally precludes the Commonwealth from trying a defendant more than once for the same offense. To determine whether the declaration of a mistrial is manifestly necessary, the trial judge balances the defendant's valued right, to have his or her trial completed by a particular tribunal against the interest of the public in fair trials designed to end in just judgments. And then they cite the case law for that proposition. The decision to declare a mistrial is entrusted to the sound discretion of the trial judge. Trial judges receive such discretion to avoid the possibility of coercive measures being used to force jury agreement, thereby protecting the fairness of the proceedings. In evaluating whether a trial judge abused their discretion in declaring a mistrial, a reviewing court considers whether the judge carefully explored alternatives to a mistrial and whether counsel were given full opportunity to be heard. If these principles were followed, then there is no claim of insufficient evidence to support a conviction. No, if these principles were followed and there is no claim of insufficient evidence to support a conviction, double jeopardy will not prevent the defendant's retrial. The defendant has not argued that the evidence presented at her first trial was legally insufficient to sustain a conviction, and thus we do not address that issue. That's the footnote. Here we discern no abuse of discretion in the trial judge's decision, decision that the jury were at an impasse and that a mistrial was manifestly necessary. All right. 83% of you say quick review and next motion. All right. We're going to zoom through their thinking. And then Miguelina, in my prep document, I have the public link for this decision from mass.gov. So if you want to link that in our description, if you guys want it, we will just make the public document available. So you guys have it from mass.gov so you can grab it. All right. The note stated that they had conducted an exhaustive review of the evidence, given diligent consideration of all disputed evidence, followed the judge's instruction to continue their deliberations. The jury deliberated another 5 or 6 hours, spanning a Friday afternoon and the following Monday, before sending a second note. The note stated the jurors were deeply divided by fundamental differences and that consensus was unattainable, echoing language from other cases where we have characterized a jury's report of deadlock as unambiguous. And that's the key. The key here is that it was unambiguous. So the unambiguous is part of the issue. So let's zoom through this because the chat has spoken. Because tomorrow we're going to cover a hearing that's happening today. And then we won't bump this. Thank you, chat. So we'll zoom. They are going to go through the second note. Let's get to their next point of reasoning. I mean, we already know what they ruled. They are going through the notes again on the court's declaration of a mistrial at length. I want to see what they say about the jury. That's a long discussion. That was a long discussion on the mistrial. Like longer than I anticipated. Defendant's claims of acquittal. We are now on page 26. That was a extensive discussion about the judge's discretion on a mistrial. Rolling along. AVD is not the judge that Emily always talks about. No. Amy Van Dyken is a Olympian and American hero. Judge Abby is a whole different situation. Amy may judge, but she's never going to tell you. No, that's not true. She'll tell you sometimes. The defendant's claim of acquittal. The defendant separately argues that she cannot be retried on count 1 or count 3, regardless of whether mistrial declaration was proper. She contends that post-trial information from 5 deliberating jurors, footnote 14, indicating that the jury were deadlocked only on count 2 and had unambiguously found her not guilty on counts 1 and 3, effectively amounts to an acquittal of those counts. Alternatively, she asserts that the trial judge abused her discretion in denying a post-trial inquiry to verify these accounts of juror deliberations. We examine each contention below, which I'm curious about. Let's go to those 2 footnotes. Footnote 14. For the purpose of adjudicating the motion to dismiss, the trial judge accepted the purported juror statements as true and accurate. For purposes of this discussion, we similarly proceed from the assumption that these affidavits were accurate. They're saying we don't need to get into this any further. We're assuming all of that's true. The answer is still no. Footnote 15. Juror C did not disclose information indicating whether the jury had unanimously agreed that the defendant was not guilty on count 3. They're like, well, actually. Claim of acquittal based on juror disclosures. The double jeopardy clause of the United States Constitution prohibits retrial for the same offense after an acquittal. Yes, yes. Relevant here, the let me answer Magdalena real quick. Sorry, Chad. Relevant here, the fundamental requirements for a jury's issuance of a verdict in a criminal case are set forth in the Massachusetts rules. Pursuant to the rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. That is the rule. So that's why we're here, because that didn't happen. A valid jury verdict must be unanimous and returned by the jury to the judge in open court. That's why the defense was arguing form over substance. And that's why the court is saying no. Our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. And then they go through the case law on that, saying the exact same thing a million times over. In other words, the distinction between informal agreement on a verdict and the actual return receipts, screenshots, timeline, and the actual return receipt and recording of a verdict in open court is central. Only the latter constitutes a final verdict. So like the case law says repeatedly that unless you have return receipts recording, you do not have a verdict. And that is, the judge is reaffirming longstanding jurisprudence. Courts aren't going to do anything weird. That is the law of the land. That has been the law of the land. We're not changing the law of the land. Hillary, this is a fantastic question. Hillary said, will it be the same jury? No. Whole new jury selection. Whole new mess. Because if you hadn't heard about this case before the first trial, what are the chances that you've heard about it now? Whole new jury. They go on to say, in this case, it is undisputed that the jury did not announce a final verdict on any charge. And then they parse the note more. They did not affirm it in open court. They go on to say The defendant nonetheless argues that any lack of formality in the jurors' intended disposition of of counts 1 and 3 should not prevent those dispositions from taking legal effect. However, the requirement that a verdict be returned and affirmed in open court is far from a mere formality. Rather, these principles recognize that as a practical matter, jurors may agree in the course of deliberations to a tentative compromise on the facts of a case or on the disposition of related charges as an attempt to reach unanimous agreement. Horse trading. They say requiring a jury to publicly affirm their verdict in open court serves a vital purpose. It ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny rather than a tentative compromise. I agree. And I think that's why polling a jury is critical. I agree. However, I think that also goes for unable to reach a verdict. If you are unable to reach a verdict, I think the question is, to each juror, it has been indicated that you are unable to reach a verdict on all counts. Is that true? And some of the jurors seemingly would have said no. And then we wouldn't be here. Request for post-trial jury inquiry. Finally, we consider the denial of the defendant's request for a post-trial juror inquiry. This is the one thing I was like, maybe. Generally, a judge is not obligated to investigate jury deliberations unless there is evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. Remember, I said there were 2 narrow circumstances when you can inquire. The top circumstance is Murdaugh. The bottom circumstance is, hey, you can't convict people based on racial or ethnic bias. And if there is indication that a jury did that, you can ask them about that, because that is then not a fair conviction. So the Murdaugh situation is one of these 2 very limited circumstances that are the law of the land and have been long-standing the law of the land. Even in cases of alleged bias, judicial inquiry cannot delve into jurors' subjective reasoning or deliberative content. Because the trial judge is afforded broad discretion makes it very hard to challenge what the trial judge did, because it's their job. There's no supervisor. That's just their job. Because the trial judge is afforded broad discretion in assessing whether the post-trial juror inquiry is appropriate, we review that determination only for an abuse of discretion. And abuse of discretion is very rarely found in appellate courts. Very rarely found. And on these notes, and given the case law, I do not think this is an abuse of discretion. It doesn't mean I like the result, but I do not think it is an abuse of discretion. I think it is legally the proper, this is a legally proper result. I don't like the way it is shaken out, but it is a legally proper result. And the defense knew that this was a long shot going in, and that their best shot was to try to get an inquiry into the jury. That was their closest, and that was still a long shot because the case law and the jurisprudence is real clear. The defendant concedes that the affidavits do not indicate exposure to extraneous matters or juror bias that would suggest her right to an impartial jury was compromised. That's honest. Instead, defendant argues that the affidavits suggest an unannounced verdict warranting further inquiry. Yet, as discussed, a verdict as a matter of law requires public announcement in open court. No verdict exists if none were announced. Period. No verdict exists if none were announced or even intended to be announced by the jury before they were discharged. Once the jury have been discharged, they have no further power to deliberate or to agree to a verdict. This was always my concern. How do they unring this bell? Even if they inquire of the jurors, the jury's been dismissed. They can't retroactively fix it. The best they could have done is say the jury meant to come to verdicts and appeal to the Commonwealth to dismiss those charges, because they can't retroactively go back and acquit her. Allowing inquiry into a private agreement reached in the secrecy of the deliberation room would also contravene our prohibition on probing, Your Honor. Okay. Would contravene our prohibition on probing the content of juror deliberations. That's a turn of phrase, Your Honor. That is a turn of phrase. Maintaining the secrecy of those deliberations is the bedrock of our judicial system. It is well settled law. It not only prevents jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial process. Chat disagrees with the last bit. Chat's confidence has not been fostered. Chat disagrees that any confidence has been fostered today. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine these fundamental principles. That's it. They go on to say, were it otherwise, jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts that might be used to set aside a final verdict. That's the biggest concern. That is the can of worms that the court is concerned about. The court is concerned that if you start allowing inquiry in this way, it would upend the entire process. You can't have jurors that are told to stay offline, told to not pay attention to what's going on outside the courtroom, to just focus on court, render or not render a verdict, and then be, besieged by the public or the internet or whatever, and then be like, wait, can we have a do-over? You can't allow for that possibility. Because what happens in the courtroom is the final answer. But in the age of the internet, this concern is not a small one, and it's not unreasonable. This is a incredibly large concern of courts. So they say, nor is the defendant merely seeking juror testimony as to a mistake entered on a final verdict slip, which is allowed, apparently, but there has to be a verdict form to talk about. Here, there is no suggestion that the jury's failure to return a verdict was the result of a clerical error, like check the wrong box. The post-trial accounts do not, sorry for that, I popped on the microphone. The post-trial accounts do not dispute that the jurors had reached an impasse as they reported and had decided not to return a verdict slip on any charge as occurred. They didn't fill out the other ones. No juror expressed surprise or disagreement in court when the judge declared a mistrial based on the jury's report that they could not reach a unanimous verdict on the charges. And then they cite case law. They say, additionally, the limited exception for juror testimony concerning mistaken verdicts only results in alteration of a verdict where there has been no opportunity for outside influence. We are well beyond the time of opportunity for outside influence. Here, all the defendant's affidavits concern jurors' accounts to others after leaving the control of the court. I don't think that's true. I disagree with that. I think some of those were direct statements. I don't think all of the affidavits concern jurors talking to other people. Some of them did. Conclusion. For the reasons stated above, the trial judge correctly denied the defendant's motion to dismiss and request for a post-trial juror inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. So ordered. So that is done. If you want to read the entirety of the case law that we jumped over, the link to the docket from the mass.gov website is down below, and you can grab it. So with that, let's summarize real quick, and then we're going to get to the next motion, and then we're going to answer a ton of questions because you guys have lots of very good questions. At the end of the day, this was a difficult motion for the defense. It was always going to be a difficult motion for the defense. They were asking the court to do something that is very outside of the normal because this is an incredibly unusual circumstance. It is rare that you have jurors saying, no, wait, we reached a verdict after a hung verdict is declared and the jurors are dismissed from the courtroom. The jury was not polled. The jurors did not speak up. The defense didn't ask for the juries to be polled. And the court relied heavily on the notes of the jurors. The notes were unambiguous. The notes did not say, we are decided on some counts, undecided on others. And ultimately, that is what the Supreme Judicial Court leaned into in their decision to deny Karen Reed's motion to either reconsider allowing them to have an inquiry with the jury or to find that the judge improperly declared a mistrial. Even if they'd been allowed to inquire into the jurors, there is still not a remedy under the law that would allow a jury that's been dismissed to render a verdict. For me, I saw the ability to ask each of the 12 jurors if they had actually rendered a verdict on counts 1 and 3 as the appropriate information needed for the defense to continue to argue that those counts should be dismissed and not retried. But that would still lie in the hands of the Commonwealth. And it seems the Commonwealth is disinclined to do that. So even if the jury inquiry had happened, there is no legal mechanism to go back and render a verdict after a mistrial is declared. And the Supreme Judicial Court kept in line with that prior case law. It's frustrating. It's a circumstance where it seems that the jurors felt that the judge would give them more information and they didn't get that more information and were frustrated after the fact. If you are ever on a jury and you are not sure what the judge is going to do, ask. Ask the bailiff that's dealing with the jury. Ask the court if you feel that you must. Ask the questions. It's better to get the answers than to leave it lingering. None of those notes from the jury, and we went back through them today, indicate that they had reached a verdict on some counts. If the notes had been less clear, or if the notes had indicated that they had reached some verdicts, this might have been a different result. But what happens from here? Trial starts on April 1st. There is no lingering ruling from the Supreme Judicial Court, and trial will begin again on April 1st. But if you're the Commonwealth, from my perspective, you have multiple jurors coming forward saying that there was not enough evidence on multiple counts in this case. it should give the Commonwealth pause going forward with those counts. It doesn't seem like it's going to, but it should. And if you're the defense, you know where your challenges are on those lesser included in count 2, the DUI related homicide counts. And that should also give the defense quite a lot of information in where they really dial in their closing arguments and their evidence in pointing out what the Commonwealth did not prove in the next trial. So the information from the jury is going to inform what happens in trial round 2. But trial round 2 is going to go forward as scheduled. All right. Let's get back into what the defense is asking for. Emily, is your voice giving up? Yes. Are we still going? Yes. Are there going to be more motions filed today? Yes. Why? Well, because of the scheduling order. Let's take a look at that real quick. And then we'll get into the last defense motion, then questions. Here's the scheduling order. Let's go through this. This is the updated scheduling order. Scheduling, Emily? Yes. Words are hard. Updated scheduling order, February 11th. Look, it's today. All of the motions except the motion to dismiss are due today. So there will be a lot of motions. Are we going through those tomorrow? No, probably not. Will we go through them? Yes, we will. I'll probably summarize them, but yes, we will. February 14th, Friday, Valentine's Day. Parties to file all their pretrial conference report. February 18th, evidentiary motions or voir dire hearings. So what day is that? Where's my calendar? Tuesday. We will be back in court in Massachusetts on Tuesday, the 18th. And then we will hear the motions on all of this stuff that's due today. So we'll probably just summarize it before the hearings and then do the hearings. Filing a defendant's motion to dismiss is due February 21st. That is a Friday. So we will cover it afterwards because the Commonwealth's response is due the 27th. They get like a week. March 4th and 5th, hearing on the defendant's motion to dismiss and the evidentiary motions. March 6th, reciprocal discovery from defense. March 7th, final pretrial hearing. March 18th and 19th, motions in limine. April 1st, trial, which is jury selection, which is probably going to take a week. So second week of April, we will be back in trial on this case. Brennan has said it's going to go faster. We'll see. We'll see. So that's the scheduling. That's what we can expect. We'll see what happens. All right. We need an update on Trooper Proctor. I promised a quick update. We've got a quick update for you. So let's do that next. You might remember that Trooper Proctor is in the middle of disciplinary hearings. Yesterday was day 2. Guess what? There's going to be a day 3. I know. This is coming to us from Boston 25. God, I hate how much shit moves on screen with websites, with news websites these days. Emily, these websites these days. Yes. It's annoying. It annoys nope, that's the wrong one. It annoys the crap out of me. So this is from yesterday regarding, this is just fighting with me today. We're going to do that. Sorry if it's not big enough to read. I'm going to read through it real quick, but there was too much stuff moving on screen. Trooper Michael Proctor, lead investigator in Karen Reed case, faces state police trial board. This is a disciplinary action. He was at day 2 of a full hearing. Day 2 of the hearings wrapped on Monday at state police headquarters in Framingham. Without a conclusion, the next hearing is scheduled for March 13th. These are private. They are behind closed doors. So they are going into day 3. These are all of the due process. If he is going to be terminated, he has been suspended without pay since not very long after the mistrial. He continues suspended without pay, but these are the disciplinary hearings to see if he will be terminated or not. I hope that these will resolve before April. But we will see if this gets kicked out past the next trial. I'm going to have some thoughts about it. I'm going to have thoughts. But the hearings continue on March 13th. So it's getting close to trial time. That's the update on Trooper Proctor. Yeah, I would love to listen to it too, but they are sealed administrative hearings. All right, let's get to the defense motion to compel. And then we're going to get to questions. So is there other stuff going on in the law? Yes. Are we going to get to all of it today? No. We're going to have to decide what to do tomorrow. Members, don't worry. I'm going to put up a poll about what we do tomorrow for all of y'all. So I will be in the member spaces asking. Oh, come on. Just motion. I want you to go onto the screen. Stop it. Stop fighting with me. I do not feel good. Rude. All right. Let's go to the defense motion to compel. One more motion. All righty. Let's swoop. Though a lot of motions are due on February 11th, 2025 in the Karen Reed case, the defense filed a motion ahead of all of those on February 10th that we're going to look at now. It is their motion to compel the production of a forensically sound, that's the key word, forensically sound copy of the videos that we heard about at the last hearing. Their motion to dismiss is not due yet. So I know the questions are going to be, why isn't this case going the same way as the Baldwin case? Why hasn't this been dismissed yet? That question is not in front of the court yet. The defense motion to dismiss is due February 21st. The Commonwealth's response is due February 27th, and there will be a hearing on it after that. That question is not in front of the court. But the defense is laying the groundwork for their motion by saying, hey, give us the evidence. Where is it? To force an answer and a clear answer from the Commonwealth. Because new information was learned last hearing where we learned that apparently somebody has some amount of information on some kind of iCloud drive. I'm hoping this motion illuminates that for us a bit more because the defense is going to have more information than we had at that hearing. And I was like, that's all new information. What? So let's see what the defense has to say in their motion to compel the turning over of a forensically sound copy of all the videos. Do we think that that exists any longer? Because I think the defense is hedging on the limit does not exist. The video does not exist. And the metadata does not exist. That's where I think they're going. All right. This was filed yesterday. We're going to go down to the last page. This was filed yesterday, to the best of my memory. It's dated February 7th. I just saw it yesterday. My bad. Filed February 7th. I saw it yesterday. I thought it was filed yesterday. Either way, we're covering it now. All right. This is defendant Karen Reed's motion to compel production of a forensically sound copy of the January 29, 2022 video surveillance footage in law enforcement custody. I need to know all the things. I need to know everything. Now comes the defendant Karen Reed and respectfully moves this honorable court pursuant to Brady versus Maryland and Massachusetts Rule of Criminal Procedure 14 to compel the Commonwealth to produce the video surveillance footage from the Canton Police Department between January 29, 2022 at 12 a.m. and January 29, 2022 at 11:59 p.m. and all metadata and logs associated therewith. Those don't exist. We know that those don't exist. We know that they don't exist. Should they have been preserved? Yes. Were they preserved? No, they weren't. The limit does not exist. And that is going to be a problem because the court should order them to turn it over. The court should say, give them this stuff. And the only answer is going to be, we don't have the stuff. Like, what else can the Commonwealth say? There needs to be an explanation of where the fuck it went. But at a hearing, Brennan is like, in the interest of transparency, somebody who's retired downloaded some video onto some drive that may also be iCloud. Okay. On January 22nd, 2025, the Commonwealth disclosed for the first time that additional video surveillance footage taken from Canton PD may be in the possession of law enforcement on a retired detective's work computer. If you're retired, do you still have a work computer? Unless the data at issue is properly forensically imaged and preserved, the corresponding logs relating to the video surveillance footage, which should contain the identity of the individuals who accessed the surveillance system, the date of download, etc., and underlying metadata associated with the actual files. Your Honor, not the fake files. The actual ones. The underlying metadata associated with the actual files will be destroyed. I think the subtext of that is, if it hasn't been already. Like, I'm not holding out a lot of hope. I think the best the defense can hope for here is transparency. I also think that the defense is making this motion knowing that it can't be turned over and then giving them better groundwork to argue from there. Excuse me, Your Honor, can we please have the metadata that we should have had in 2022? The Commonwealth has indicated that it is objecting to properly forensically imaging the computer and or the department's video file system such that the defense can obtain a forensically sound copy of the requested information. What do you mean? I need more information. I'm going to need more. I want to see the Commonwealth's response to that. Is the Commonwealth objecting? Or is the Commonwealth saying you can have forensic imaging of the relevant data, but not the entire computer? I have questions about where the parsing is on this, because there should be no objection to forensic image of this information, but not of the entire computer. If it's a forensic image of the entire computer, then I can understand the objection. That's overbroad. The metadata underlying the video files at issue is not only central to the case, but is also exculpatory. And if properly imaged, will potentially reveal significant exculpatory, relevant, and material information about the underlying data, namely dates of creation and information pertaining to whether any of those files were altered in any way, which matters in this case. I don't disagree. It is absolutely necessary that this information be obtained in a forensically sound manner. Agreed. Unless the Commonwealth images the drive at issue and obtains this critical evidence in a forensically sound way, the Commonwealth will deny Ms. Reed access to exculpatory information, which underpins some of the most highly contested and important evidence in this case. This is groundwork. The Commonwealth's proposed process will destroy critical evidence, namely relevant and exculpatory metadata underlying these video files, in violation of Ms. Reed's constitutional right to effective assistance of counsel and due process. Okay, all the rights. Just listed everything. Rights reserved. All. Don't fuck with us. It's a summary. In addition to her constitutional rights at all, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Yeah. The rules of criminal procedure clearly state the Commonwealth must provide certain mandatory discovery of evidence within the possession, custody, or control of the Commonwealth to the defense in order to meet its discovery burden. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, tangible objects. I mean, this counts as a photographed and a tangible object. No, Nickelback did not sing Photograph when I saw them live. I know. I'm mad too. They did sing Rockstar. I have video, and AVD has video, and I'll share the video. I just haven't had a chance to sit down and do it yet. I was playing Midas Merge on the plane. Turnover evidence. Yes, and they go on to say they are also must turn over any facts of an exculpatory nature. Yes, and. The rule also indicates that the defendant may move for discovery of other material and relevant evidence not required by the subdivision. Ms. Reed respectfully requests that this court order the Commonwealth to provide the requested discovery, to which Reed is entitled under Rule 14, and other Massachusetts rules and the Constitution. RK, I know. How would they remind me if they didn't sing? I know. Factual background. Oh, goody. What the fuck is happening? Just what is happening? Stina G, they sang the real Rockstar, but I do love the sea shanty version quite a lot. Factual background. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe. We know. Second-degree murder, manslaughter under the influence, leaving the scene. Let's get to what the fuck is happening here. On October 5th, 2023, this court ordered the Commonwealth to produce all video. There should have also been one before that, but okay. On October 5th, 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. See Exhibit 1. Good. There's the order. In spite of this standing court order, the Commonwealth recently notified the defense that additional video surveillance footage from Canton PD recorded on January 29, 2022, and the metadata associated with the footage may be in the constructive possession of the DA's office through its agents, Canton PD. The Commonwealth's proposed protocol for obtaining this information will destroy relevant metadata associated with it. What did they propose? And how would it destroy the metadata? It might not give a forensic copy to the defense, but it shouldn't destroy it. I've got questions. Don't worry, Chad. I'm going to keep reading. Also, this should have been turned over prior to the first trial. That was in 2024. I know it feels like it was 700 years ago. They were ordered to produce all video in 2023. I'm still surprised, maybe I shouldn't be, but I am, that the video was allowed to come in when it was discovered during trial. You were ordered to turn it over in 2023. You didn't, you don't get to use it. At a minimum, you don't get to use it. There can be more, but at a minimum, you don't get to use it. Procedural history. Oh, good. Tell me more. Procedural history relating to Canton PD video surveillance footage. A brief summary of the procedural history relating to the video surveillance footage at issue is set forth herein. The Commonwealth has provided the defense with CPD video footage on 3 occasions, footnote 1. Footnote 1. I can't footnote voice. I am a little under the weather. I will do my best. Notably, when Mr. Erickson arrived at CPD, this is in the other motion. Notably, when Mr. Erickson arrived at CPD to extract the video DVR system, the security camera system was set to overwrite older video surveillance footage with new footage after approximately 30 days. Notably, however, each of the 3 instances in which the Commonwealth produced the footage to the defense was far outside the 30-day window, after which the system was set to overwrite the older video. Thus, therefore, an agent of the Commonwealth must have saved, it's the only way that happens, must have saved all of the nope. Defense? No. Nay. I disagree with that. The word you're using there is all. Nope. An agent of the Commonwealth, they say, must have saved all of the aforementioned footage. They necessarily saved the footage that was provided. I do not know if they saved all of the footage from that day. But yes, they must have saved the footage that was provided because it was provided. It exists, therefore it exists. I don't think they saved all of it though, but we don't know. Maybe we'll find out. They must have saved the footage that was provided in a playable format at some point before the end of the 30-day period. Agreed. Which ended in February 2022. The Commonwealth therefore had care, custody, and control of all of the footage produced to date during the discovery phase of the initial trial and chose not to turn it over in a timely manner. Agreed. They had to have saved it before the end of February 2022, and they did not turn it over. Agreed. Because they didn't turn it over. On April 4th, 2024, well after the October 5th order, on April 4th, 2024, shortly before the first trial in this matter, the Commonwealth produced footage from the main driveway and the Sally Port for the first time. The Sally Port front wall footage provided by the Commonwealth omitted a 42-minute interval. There was some argument whether, and again, this is adversarial writing. There is much argument over whether it was omitted or it didn't record. You know what would resolve that argument? Yeah, the metadata. The metadata should resolve whether it was omitted, whether it was never recorded, whether it was deleted, whether it wasn't saved, all of it. The metadata would just answer the fucking question. So there was a 42-minute interval that was not provided and or not recorded, during which the SUV arrived at the CPD Sally Port garage. I want to know if it's motion captured, why it didn't capture an SUV moving around. Excuse me. One would think that that is the type of motion that would be motion captured. The missing footage could have been used to show the condition of the SUV's right taillight upon arrival to the Sally Port, and to date would be the only footage that serves this would be the only footage that serves this purpose. I was really hoping in the first trial that we would see photos of the state of the SUV when it was towed. I was really optimistic. We did not get very good photos of the SUV when it was towed. This would be the only footage of that. And I agree with them that that's critical. The condition of the right rear taillight of the Lexus SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in the case. It is critical. Mid-trial, April 23rd, 2024, via a share link entitled Additional Sally Port Video Download Link. Can you imagine getting that email? I can. And I imagine the response would be, what the fuck is this? Are you fucking kidding me? You've got to be fucking joking. What the fuck are they doing? You fucking kidding? There's more, I think, that would follow that, but it's probably not appropriate for the internet. But I can imagine it in my brain. Y'all can insert it into your own inner dialogue. Middle of trial, additional Sally Port video download link. You're fucking joking. The Commonwealth produced additional footage from CPD Sally Port back wall. At trial, Trooper Buchanan testified on direct examination that the footage of Reed's vehicle from this interior Sally Port camera was an accurate depiction of the Sally Port and the SUV, and that as seen in the video, no law enforcement officer approached the right rear taillight. But that ship was flipped. R.ESQ, I don't know if they moved to exclude, because so much happened at sidebar. I don't know if they did or if they didn't. And the sidebars are still impounded, so we can't go back and look. I imagine that at sidebar things were said, but we didn't see it on the record. So, I would guess that was all sidebar conversation of like, Your Honor, we have an issue. But the court was very locked down on the public not seeing what the jury didn't see. Except for, at least there was transparency on the days that they did voir dire. That was helpful. On cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted. It was apparent to the chat immediately. Chat was like, that shit looks weird. That shit's flipped. That looks like a 4. That's inverted. I'm like, somebody should ask about it. It took them a day to ask about it. The Commonwealth never asked about it. Y'all were immediately like, what the fuck? On cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted. Yeah, it was keeping up international relations because it was inverted. And a mirror image of reality, despite neither the Commonwealth nor the trooper having mentioned it on direct examination. Therefore, when the video appeared to show a person standing near the left rear taillight of the vehicle, in actuality, the person was in fact standing near the right rear taillight. I think it just made the Commonwealth look shady. Let me know what you guys think. The Commonwealth not addressing it till after cross-examination just looked shady. I think it made them look terrible. It remains unclear. We need more water. It remains unclear why this inverted video was withheld by the Commonwealth and produced to the defense in the middle of trial after the initial surveillance footage was turned over. Where did it come from? Where was it hiding? Why wasn't it all just in the same file? Why wasn't it all saved in one place with metadata? I think it just made them look terrible. Most recently, post-trial on October 10th, 2024, the Commonwealth again provided new video surveillance footage.
Bruh.
The FBI!
I'm just going to start like pawing the soundboard. Like,
Bruh.
videos turned over during trial, videos turned over just right before trial, and then videos turned over after trial. On October 10th, 2024, 2 years after they were ordered to turn it over. No, a year. That's a year after they were ordered to turn it over. The Commonwealth again provided new video surveillance footage. This time from CPD, church side exterior, first floor corridor, near rear lot main side and rear lot cruiser side angles. So 1, 2, 3, 4 different angles. This footage shows Brian Higgins arrive in the parking lot of Canton PD at 1:26 a.m. How smoothly was he walking? I've got questions. Enter the Canton Police Department and is seen speaking on the phone to some unidentified individuals. On the phone, that's an awkward sentence. Is seen speaking on the phone to some unidentified individuals on the phone as he is leaving the Canton Police Department at 1:34 a.m. When did he move the cars? When did he move the cars? In the snow. When did he carefully rearrange parked vehicles in that period of time? Less than 10 minutes? Higgins, I got questions. But wait, the phone's been rehomed. So some of those questions aren't going to get answered. Significantly, this material and relevant evidence, which establishes Brian Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left Canton PD shortly after John O'Keefe's death, was withheld from the defense at the first trial. Yep. That's a problem. The video surveillance footage at issue was a major point of contention at trial, in no small part because the Commonwealth was utterly unable to establish any chain of custody for the various clips of the video. How does it become evidence? Like, if there's no chain of custody, how does it even become evidence? The video surveillance footage, I'm repeating myself. The Commonwealth was utterly unable to establish any chain of custody for the various clips of the video produced to the defense from Canton PD. The footage produced by the Commonwealth is rife with issues that call into question the accuracy and forensic viability, including the presence of the inverted video and the large-scale gap missing from the feed at the precise time at which Miss Reed's Lexus should have been shown entering the Sally Port. In spite of the fact that the Commonwealth claims the video surveillance feed is motion activated, wouldn't an SUV activate the motion? The fact that Canton PD produced video surveillance with an inverted video and a gap in the footage at a critical moment is not trivial. It goes to the heart of Miss Reed's defense. In preparation for trial, the defense requested access to the CPD DVR system. We've heard how that went. Defense expert went to obtain the files and the associated logs, and the CPD technicians went, meh. The way the CPD technicians extracted the video data from the DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then the data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original. This was in their last motion. And because it exists in different format, the resulting file will not hash verify to the original. Forensic experts cannot properly test the authenticity and integrity of the video. In response to the defense request, ADA Brennan, or Special ADA Brennan, agreed to allow the defense access to the critical information. Accordingly, they traveled from Phoenix to Boston, December 11th, to make arrangements to download it. When he arrived, they were like, I don't know what you're talking about. Weird. Facts relating to the attempts to meet and confer. Ooh. Tea. Here's the tea. Here it is. And here's the thing. I give attorneys a hard time often, for a variety of things, for too much. At some point, even for me, the level of hyperbole is unhelpful. Like going from 0 to 60 doesn't often work for me. It's like you've got to earn the mad. I feel like A, we've earned the mad at this point, and B, we have toned down the hyperbole. We know this judge does not like it. We have seen it time and time again that when the language gets too adversarial, that the judge is like, I don't like that. I don't like it. But I find that the more profound the problems get, the more toned down the defense is. There's no need for hyperbole at this point. The defense doesn't need to bring in the emotional and emotive language. There is no banging the table needed because the actual facts are so bad. You don't need to make much of it other than to say, this is what happened. This is what happened is bad. It's not hyperbole. It's bad. When lawyers go way above and beyond to try to pull the emotional response when they don't have the facts yet to back it up, it's too much. This is not too much. And it's getting toned down every time we see emotion. They're just like, this is just what happened. No need for anything extra. And if you've noticed it, if you've looked at the defense writing across this case, you will see it as the facts get crazier, the defense level of hyperbole goes down. Also, then you don't have people going, well, the defense are just running around saying this or saying that or whatever. They're just saying what happen from their perspective. Their perspective is always going to be adversarial. I'm interested to hear the Commonwealth's response, but the Commonwealth didn't controvert that the information's not on the DVR system. They did say that they told the defense there that it probably wasn't on the system. After Miss Reed expended significant resources to send an expert to Canton PD to image the DVR system, on January 22nd, 2025, defense counsel received a call from Brennan. Tell me everything you talked about. What did he say? What did you say? And then when she like, yeah, I don't know either. I want to know. Brennan indicated that he recently obtained information from who? Like somebody's Finsta? Like where is... I received information. Where? What? I received information from where? Brennan indicated that he recently obtained information that a retired Canton police officer had Name him. Which one? I find it critical to know which retired Canton PD officer in all of this mess. Who? A retired Canton PD officer downloaded the surveillance footage at issue on his work computer and cloud-based account. Work cloud-based account? Personal cloud-based account. Questions. He informed defense counsel that he was going to have his own expert download the surveillance footage, but would permit our expert to fly back to Canton to be present for the imaging. At the hearing on February 6th, the court invited both parties to meet and confer informally, as I remember, on the issue of the video download in order to obviate the need for further court intervention. Great use of the word obviate. The defense did this in good faith. I would hope the Commonwealth did too. It doesn't seem like the defense feels that way. On February 6th, defense counsel met and conferred with the Commonwealth regarding obtaining the requested video surveillance footage and associated information. Oh, baby, no. The and associated information part is where we're getting all tripped up here, because here's what happened. I don't even need to read this to know what happened. Here's what happened. Whoever saved it used the DVR system to convert it into a playable file and save the playable file. It was always saved as a playable file. There's no indication that this was ever saved in its original format at all. On February 6th, defense counsel met and conferred with the Commonwealth regarding obtaining the requested video surveillance footage and associated information from what had been varyingly referred to by the Commonwealth in separate discussions as retired detective's work computer and the Canton Police Department's detective file. This meeting must have been interesting. Following the meeting, Attorney McLaughlin sent an email stating that, quote, the Commonwealth will attempt to download any videos to the extent they exist, which are related to your client's vehicle at the Canton Police Department and presently stored on the department's video file system. We know it's not on your video file system. They went to extract your video file system. It's on some dude's computer, apparently. The video file system doesn't have it. The Commonwealth will video the process and produce documentation of the retrieval process and any responsive videos. Attorney Little responded requesting that, quote, the Commonwealth's expert conduct a full forensic image of the computer and, that's the problem, and or video file system at issue, such that our expert can obtain a copy of all available metadata relating to any of the videos at issue, including any log files associated with the videos, and or deleted data that may be recovered from the computer. I understand why they want the whole computer. I understand why the Commonwealth is hesitant to give it to them. You can't just turn over an entire forensic image of a law enforcement computer. That's not going to happen. But there should be a more narrow request. Special Assistant DA Hank Brennan then responded, indicating the Commonwealth would not be obtaining a forensic copy of the information at issue. I have questions because the request is overbroad. And I imagine Brennan's response was something along the lines of, we're not downloading the entire computer. When Attorney Little requested that the Commonwealth ensure all metadata associated with the related files and associated logs are copied onto a thumb drive, Attorney Brennan objected and indicated the defense would need to file a motion with the court. Nope, I'm not as annoyed as I thought I was. Here's why. I think Brennan is like, this is pure speculation on my part. Pure speculation on my part. I think this is a CYA move by Brennan. I think Brennan is like, yeah, I'll give it to you, but you need the court to tell me to give it to you. I think this is a CYA. Sure, you're going to need to make a motion with the court. Tell the court to tell us to turn it over. That's my speculation on this, because the Brennan is not just going to volunteer an entire laptop. You can't. It's way overbroad. But you can narrow down that imaging per the court's request and say, send me a court order. And I'm going to say, and Brennan's probably going to argue to the court, we're not forensically imaging the entire computer. So let's narrow it down. So I think this is not a, we're not turning all this over, but I think there is some disagreement about what level of forensic imaging is requested. And the defense is requesting the entire computer. And that is overbroad. And I imagine Brennan said, no, that's overbroad. So I think that's where the disagreement is in narrowing this down. I want to see the Commonwealth's response on that. I don't think this is going to be withheld. I think this is going to be turned over. I don't think that the metadata regarding the original video exists, but the metadata of when it got onto the computer, the metadata of what got onto the computer, the metadata if anything was deleted from the computer, that may still exist. But you can't forensically image the entire computer and turn it over. Hopefully that makes sense. But it should be preserved, and they should get a forensic copy to see if anything was deleted. And Brennan said, file a motion. And so filing a motion. On February 6th, Attorney Little responded stating, if the Commonwealth is objecting to properly forensically imaging the computer, yeah, they are. Yeah, they are. Because the Commonwealth's position is we turn over the video on a thumb drive. We'll put the video on a thumb drive, but we're not going to image the whole computer. That is a valid fight. I know a lot of you aren't going to agree with it, but department computers don't get turned over like this. That's why there's a DVR system, and you download the DVR system so you don't have to download an entire detective's computer. Now, the court might say download the whole computer. The problem is they're on a time crunch. The court could say download the whole computer and it goes to a neutral third party so that data and sensitive information on other investigations doesn't get turned over, and have a neutral third party forensic examiner go over it. The court can do that. It should have been either on a forensic image on a hard drive or on a forensic image on the DVR system, so you don't have to do this. But we have seen this court say, yeah, give them the entire phone. If you're putting it on your computer, you've opened your computer up for it. So the court could do that too. We'll see. But I can understand the Commonwealth saying, yeah, the court's going to have to tell us to do that. It goes beyond our obligations. The metadata issue is an issue. On February 6th, Attorney Little responded stating, if the Commonwealth is objecting to properly forensically imaging the computer and or the department's video file system, if that's the DVR system, we already know the results of that, such that we can obtain the information we have been requesting, namely all video footage from the Canton Police Department on January 29th, 2022, like the full 24-hour period, and all metadata and logs associated therewith, which we all suspect have been destroyed, either maliciously or by being overwritten because they weren't ever saved, just the playable videos were saved, then I will file a motion with the court tomorrow. This information needs to be obtained in a forensically sound way. That is all we are asking to have happen. I don't disagree. As of the filing of this motion, the defense has received no response from the Commonwealth. I was like, file it then. File it then. The defense does not want to expend additional resources and send an expert to obtain this information. Rather, it is simply requesting the Commonwealth, which has retained not one but two digital forensic experts, forensically image the device in question and ensure that the data is obtained in a forensically sound way. That's going to have to be narrowed. Absent this court's intervention, the Commonwealth will be permitted to destroy critical metadata underpinning one of the most seminal pieces of physical evidence in this case in violation of Brady and the Massachusetts Rule of Criminal Procedure 14A. As such, the defense seeks immediate relief from the court. What relief will be crafted will probably be narrowed down from the entirety of the computer. I'm interested to see how the Commonwealth responds to this, but the problem is a lot of what they're seeking is probably already gone. And I think they know that. We're talking about two different types of metadata at the moment. So the metadata from the original DVR, I think is gone. I think it overwrote in 30 days. I think they downloaded the videos that they selected. I want to know, if I'm the defense, who sat down at the computer terminal or whatever and said this video, this video, this video, this video, and saved them. Who did that? I don't want to know. Somebody's like, oh, it was just in a file somewhere. Who picked what to save? How did they make that decision? But that DVR overwrote in 30 days. They downloaded them, which seems to be their habit and practice. They downloaded them in a playable format and saved them somewhere. Who did that? Where did they save them? It sounds like they saved them on this computer. Great. So then that computer's metadata should show when those files were saved, what files were saved, what programs they were saved in, what programs opened them, if anything was deleted, altered, flipped, manipulated. The metadata on that computer system should also have some information. What it's not going to have is the metadata from that original DVR system. Both is a problem. Oh my goodness. Victoria asked, is this a full Brady violation yet? I want to hear what the Commonwealth has to say. I want to go through the Brady steps in Massachusetts when the Commonwealth responds. Here's what's hard about this case, where it's not as easy to say, yes, this is Brady that requires this result, because it likely is Brady. What result comes from that, I want to know. It's very difficult for the defense to argue that this is Brady when it doesn't exist. And that's the case law I want to see in how Massachusetts tailors that. Because saying it's exculpatory when it's been destroyed is a difficult argument. And that's the point of Brady, right? You shouldn't have to make that many leaps. So is it potentially exculpatory? What does Massachusetts say? Let's look, because I bet they're going to get into it. I want to see the whole motion to dismiss before I just tell you, yes, yes, yes. Because there is case law that governs this. And I have not done a deep dive into that case law. And I don't want to tell you just like vibes. It's concerning. And it should have been turned over. Pursuant to Brady, which mandates that the prosecution turn over all exculpatory evidence. The Commonwealth must comply with the aforementioned request. How do you define it, though, Massachusetts? Where is your... I don't know if they're going to get into all of it because this isn't their motion to dismiss. A prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participate in the investigation. Yes. Yeah, they don't get into the definitions. I will start to deep dive this, but we will get a full breakdown of how the case law balances this in the motion to dismiss. Because when we went through New Mexico and their case law, the way that New Mexico handles things that happen during trial versus after trial are different. There's like a two-prong approach. So I'm curious to see what the case law says here. Music to my soul says, Emily, why look at the case law? Just say upon information and belief. I will say the vibes are off on this getting piecemeal turned over to the defense. 100%. But I want to look at what they describe the evidence as, because the Higgins stuff, I could see the court arguing that it's not exculpatory, or the Commonwealth arguing it's not exculpatory, it's impeaching. And I could see there being some nuanced arguments there, which is why I want to go through the case law to see how it's defined in Massachusetts, because I want to give you the legal basis for the reasoning versus the supposition for the reasoning. Hopefully that makes sense. Don't worry, we'll get there. I know everyone's anxious to get there. We'll get there. The motion to dismiss, it's coming. Apparently it's coming. On February 21st. Mark your calendars. So this case law cited just says the Commonwealth has to turn it over. It doesn't break down what is considered Brady. I'll go through it. I haven't done it yet. In addition to her constitutional rights, Reed has statutory rights to obtain evidence in advance of trial. Yes. There are rules. Society has rules, people. The Massachusetts Rules of Criminal Procedure clearly state that the Commonwealth must provide certain mandatory discovery of evidence within the possession, control, and custody of the Commonwealth to the defense in order to meet its discovery burden. Information subject to such material discovery includes material and relevant police reports, photographs, tangible objects. Is a digital video a tangible object? I want to see the case law on that too. I think it counts as a photograph, but do photographs have metadata? Yeah, they do now. They didn't then. Creekside Casual. Your comment in the chat is literally everything. After that hearing last week, it is the most appropriate comment. So I wonder if we're going to see some argument over what counts as a tangible object, or if case law has already put things like metadata and videos under tangible objects. Intended exhibits. Also, they use these as exhibitees. So reports of physical examinations of any person or scientific test or experiments, statements of persons the party intends to call as a witness, as well as any facts of an exculpatory nature. The rule also indicates that the defendant may move for discovery of other material and relevant evidence not required under subdivision. Ooh, case law. Furthermore, as articulated in Com versus Ruddock, courts have recognized the importance of preserving metadata associated. Yay, there's case law. Of course there is. Courts have recognized the importance of preserving metadata associated with any digital evidence, explaining that the forensic examination of the computer data by an expert retained by the defense is an essential component of effective assistance of counsel. That is good case law for the defense. I would want to read the rest of it, but this is just logical. This just makes sense. You can't say you're required to turn over all video and not required to turn over the metadata associated therewith, unless for some reason you can't get it. If the police are given a Ring video camera footage by a neighbor or something, and all they can get from Ring is the photo, that might be outside of their control. And then you can subpoena Ring and bring in a Ring expert from the company and explain. But this DVR system is within their control. And that is a critical difference here. It has to be that law enforcement has to maintain the metadata, especially as we are moving into a time in the world where real video, fake video are going to be a huge problem for the courts, in my opinion. We are going to see witnesses saying, and others saying, well, that wasn't me. That's not my voice. That was deep faked. That was not a picture of me, or that is a picture of me, but I didn't allow anyone to take it. We are getting into an advance of technology that is going to make metadata even more critical. It used to be much harder to alter a photograph when you were still using chemicals to, sit there with your paper in your dark room, bringing photographs to light. It was much, much more difficult. Now, anything can be true. Voices can be manipulated. And how do you prove what is real to a jury if you don't have the metadata? It's going to be a massive problem. Victoria said, oh, I didn't even think about that. AI is about to be a huge problem. It's already starting to be. Like, law runs so far behind technology. Even simple photographic manipulation in like a Snapchat filter can cause a problem in court. Like, if a Snapchat filter or an Instagram filter or whatever shows a photo and shows your location on the filter, do you have to be at that location? Do you not have to be in that location? You need the metadata of that information to say what must be real. I mean, it used to be that you were fighting over like the timestamp at the bottom of a camera and who set the time on the camera. And if that timestamp at the bottom of your photo was the right time because you had the back of the camera and could manipulate the time. This was an issue with security cameras. Does the security camera show the accurate time? Does it not show the accurate time? When law enforcement shows up, did they note on my watch it says this time, that security camera says that time? People used to call the Dateline, whatever it was called, to check and see what the mean time was or the world time and see if that was accurate to a video surveillance. And then that would be in the police report. Oh, I called in the whatever time and date. Thank you, Anne. The time and date, called in the time and date, and it said this, and that machine said that. So then you can account for how much it's off, because if those are set by humans, sometimes they're off. Sometimes they don't account for time changes with daylight saving, like all the things. But it's so much more complicated now than it was. And without metadata, it's going to be very difficult. So law enforcement is going to have to bring in the technological experts needed to update their systems to accurately preserve, and for line detectives and officers to understand how to preserve, or know that you need a warrant and just take the device. If you can't preserve it, fine, just get a warrant, take the device. The problems that are going to be caused. I won't get into them. I don't want to teach people how to crime. That's not my side quest here. It is not my role to help people crime better. But these are the issues that I am spotting. Dude, law school in 2030 is going to be fascinating. All right. Courts have recognized the importance of preserving metadata, of course. As noted by the court in Boyd, forensic examination may provide valuable evidence as to how images and questions made their way onto a laptop and when, how often and by whom they were accessed, whether the images were actually disseminated or stored in a manner consistent with the intent to disseminate them, is a critical issue in this case. And they are talking about the case that was cited. Indeed, absent consultation with an expert, defense counsel will be severely handicapped in cross-examination of the Commonwealth's expert. That case law is good for them. Here, the requested video surveillance footage and accompanying metadata constitutes tangible evidence that is clearly relevant material, exculpatory, and necessary. I mean, it's clearly relevant material. I think the absence of video during that time period is exculpatory. I think the stuff with Higgins is probably impeaching, but I think there's room for them to argue. And necessary to Miss Reed's ability to defend herself at trial. I agree with that too. Moreover, on October 5th, 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. I appreciate that they went back and found the transcript where the court did that. This is huge for the defense. This October 5th, 2023 order is going to potentially be a lifesaver for them because it says all associated metadata. And if the defense didn't have it, if the Commonwealth didn't have it then it should have been addressed then, not in February 2025. The defense is simply asking this court to order the Commonwealth to obtain the log of this evidence. Your Honor, it's simple, really. We just want the logs. I mean, our forensic examiner went to go find the logs and they didn't find any log. Like, it's log. It just doesn't exist. But Your Honor, it's simple, really. You told them in October of 2023 to give us this shit, and all of a sudden in 2025, it's not there. Weird. This is groundwork for the motion to dismiss. The defense is simply asking this court to order the Commonwealth what they already ordered them to do back in 2023. Just give us the log and give us the evidence in a forensically sound manner. Hey, judge, just can you make them do what you told them they had to do a couple years? Can we just get back to that, please? Can you just get back to that? That order is good for them. Let's see. The exhibits aren't attached here, but I will look for them if I can find them. This court is not easy to obtain information from, but I will try to find them. Let's give a quick say, judge, can we just get the logs and the metadata? That's all. Certified forensic copy. I said certified forensic copy. It's nothing to do with Drake. Let's do a quick summary and then we'll get to questions as my brain continues to fade and I probably need a nap. Why? Because we've been streaming for 3 hours and I am a little under the weather. So the defense is asking the court for a simple request, really. Hold on. Let's read it again. On October 25th, 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. The defense is simply asking the court to order the Commonwealth to obtain and log this evidence in a forensically sound manner so that no additional exculpatory information is destroyed. This all centers around the stunning reveal that some computer has some video saved by some retired officer and maybe cloud storage. The defense indicates that they asked the special prosecutor on the case, Brennan, to forensically image the entire computer. Brennan, disinclined to acquiesce to that request, said, "You're going to need to make a motion to the court. I can understand the Commonwealth's hesitation to forensically image an entire department computer, but when the videos got on the computer, if any videos were deleted from the computer, when the computer accessed those, what file they saved them on, all the metadata related to those files is essential and should be turned over. But the original metadata, I think the defense is aware, is probably gone but they are asking again. And it seems the defense found where that order was made in October of 2023. All videos and metadata need to be turned over, and the Commonwealth still has not complied with that order because all the metadata was not turned over. And even before the first trial, all the videos weren't turned over because videos were still coming in October of 2024, well after the first trial. This is groundwork for the motion to dismiss that the defense has a deadline of February 21st to turn it over. Will the court probably issue another order to turn it all over? Yeah, a duplicate of the other order. Is the Commonwealth going to be able to adhere to that order? It seems like maybe not. And if they can't, does that give the defense stronger and more grounds to make their motion to dismiss? I think so. And we will continue to see the defense hopefully methodically laying out, these are the dates the court ordered things. The court said the metadata needed to be saved. The court said the videos needed to be turned over. And then these are the dates the videos were turned over, some not until the middle of the first trial with no metadata, and some not until after the first trial with no metadata. So not only is there an obligation for the Commonwealth to turn it over, but there is also additional court order making it very clear that it gets turned over with the metadata. How the court addresses the fact that that likely doesn't exist, we will see, because oral arguments are set for this in the beginning of March. But we are getting very close to that April 1st trial date with some very decisive motions still outstanding. So I think when we see the defense motion to dismiss, they are going to ask for it to be dismissed on all of these different grounds, including the destruction, they're going to argue, of exculpatory data. It's very hard for the defense to argue, Your Honor, they destroyed this, so we can't even tell you what it is because it doesn't exist. But I imagine the case law in Massachusetts will give guidance on what happens when things that can be exculpatory are destroyed, because you can't just say, well, it's gone, so now we can't argue that it's exculpatory. So we will see. That's not before the court just yet. I know everyone is ready for the court to just dismiss this case. I understand. The question's not before the court just yet. I'm interested to see what these motions to dismiss say. I'm interested to see what the Commonwealth says in response to this motion for the turning over of a forensically sound copy of all of these videos, because I wonder if that's even possible at this point. We'll have to see. All right, let's get to questions. All right, let's see. Let us get to some questions, and then I'm going to rest. Because tomorrow it is my goal that we go to court for a hearing that happened today, and we cover it tomorrow. That is my goal. So we'll see. Donna Adelson's got shit going on, and we need to pop back in. And then we'll get back to the rest of this, but we need to pop back in. We're gonna have to take a day break. We've got a whole bunch of stuff going on in all of the Lively Baldoni stuff, but all of us were like, ooh, that's exhausting. So we'll get back to it. We've got much to get back to. Do not worry. All right, let us see where your questions lie. Let's see. Ann Bell said, what is a Law Nerd merch peak? Ann, that's top secret. Shh. That's top secret. Don't worry. Y'all will know. Y'all will know. We do have stuff coming this week, but some of that is going to be top secret because members get first access. So we also have a bunch of Diddy stuff going on. We've got Diddy stuff going on. We've got Diddy stuff going on in the criminal case. There's Diddy stuff going on in the Diddy Jay-Z lawyer throwdown. There's lots going on. Lots of it. Why can't I get on the shop? It's closed at the moment, like the Apple Store. Katie said, try to catch a falling knife Friday, 5 stitches. Katie, I'm so sorry. Falling knives only have blades. I understand. I try to jump out of the way, but it's so hard because your brain instinct is like, ah. The brain is like, catch. Falling knives only have blades. I'm sorry. I'm glad you are okay. I have several friends who have been injured by knives in different ways. It is not good. It's one of those things. So I am sorry. 5 stitches, though, is not the worst. So recover well. Happy 8 months. Happy 8 months. Thank you, everyone who gifted memberships. J. Michael, that is incredibly kind. So many of you gifted memberships. We have lots of new members. Welcome to our new members. We were going to have members only next week. We've got some other member stuff happening. So for those of you that are new members, there will be a member tab. Don't worry. So let us continue. Congratulations, new members. Judy, you got this. Good to see you. I am definitely an excited member. It's always exciting to see the excited members. Thank you, Judy. That's fantastic. Gabrielle, I wanted to read this, so I saved it so I could read it. Next time you talk to YouTube people, can you ask about how lives turn off the phone screen if they haven't started? I can ask about that. So it sounds like the app doesn't keep the screen live while you're waiting for the live stream to start. I can absolutely ask about that for sure. Seeing everybody celebrate the Eagles win. Hello, Eagles. I love that the Philly folks are just like, fly, Eagles, fly. On the road to victory. Okay, I'm going to stop. Cynthia, thank you for the 10 gifted memberships. I appreciate it. The Say Drake smile is my lock screen. K Silks. The clips of it, every time I come across a meme of Say Drake, I can't look away. It's flawlessly executed. Literally no notes. It is like a housewife can't even aspire to that level of shade. Like, we're not even there yet. We would have to have an entire March Madness tournament on what might even come close to that Say Drake smile. I don't know. I don't know if ever we have gotten housewife close to that. I don't know if we ever have. I'm open to suggestions. But oh my. For all of you asking if I'm going to cover that lawsuit, I covered it briefly on the podcast, and I will swing back to it. I have not. I covered it when it initially dropped. There wasn't a ton of interest. There might be some more interest now. I love covering the music suits. We just need to do a whole music day. There's some other music stuff that I want to cover. So Lindsay said the entire stadium, A minor. Everybody now knows more about the musical scales than they ever thought they wanted to, unless they were musicians. But yeah, it's clever. I love clever shade. I love it so much. Carol said, yay, I've turned red. Congratulations for 24 months. I know the badges and icons change color, and we have some updates coming to the member emojis and to the member icons. We've got some fun shifts happening. Mike, good to see you. Thank you, EDB, watching from beautiful Philly, home of Super Bowl champions, EAGLES Eagles. Do I always get self-conscious that I'm going to transpose the E and the L? Yes. So I'm glad you spelled it out, because otherwise I will fuck it up. Duolingo died and they're insinuating Drake did it. I think the law nerds, look, a lot of the time I discourage the internet detective situation. Real people, real cases, real lives, real trauma, real stress. If there was ever a time to internet detective, figuring out what happened to Duo is the time. This is the time. This is the time we need to know. We need to know. And I think that's the appropriate time to internet detective. Just like what happened with Spidey D, the Dunkin' Spider Donut. There are times to internet detective. I still think Pringles was involved. I still think Pringles was involved in the disappearance of Spidey D. I said what I said. Amanda Scott said, I didn't watch the Super Bowl. I went to see Wicked live. I mean, Wicked live is amazing. Drinking hot chocolate in San Diego. I love a good hot chocolate. Laura said, got an A in my first 2 classes for paralegal study. Congratulations. Yes, Nuche, my people are actually from Philly. Philly and Jers. Yes, they are. I would give more specifics, but not on the internet, because the internet. But yes. My parents worked at the Jersey Shore. Like, the stories of them working at the Jersey Shore are wild. Like back in the day. Yes, absolutely. So, yeah, my mom left the state to go to college. My dad stayed in Pennsylvania. But yes, it is. We used to go visit my grandparents, and it was mind-blowing to me because where my grandparents lived in Pennsylvania was out in the country. It's not as country now as it was, but out in the country. And we would just be able to run around and like go pick blackberries and stuff off the side of the road. My California ass thought it was the greatest thing ever that we could just go run around. The neighbors, like the pool's open, jump in whenever. And there were just acres and acres and acres and acres. Nobody was like, don't get a tick. Probably should have been, but weren't. Oh, the best time in the summers running around just in the country and, picking berries off of bushes. So much fun. California, not the experience. No, not the experience at all. Rachie, congratulations on 2 years. My parents did not watch Jersey Shore because they worked in Ocean City, which is a dry city. And my parents literally couldn't. I am obsessed with Jersey Shore. Obsessed with Jersey Shore. We occasionally, because LA, would have people come onto jury duty that had all kinds of fancy and amazing jobs. People who were athletes, people who worked with athletes, people who worked with celebrities, people who worked in film. I had not A-list celebrities pop onto my juries, but you had people come in for jury duty occasionally and you'd be like, huh. I almost lost my shit when somebody who worked production for Jersey Shore was in on one of my juries. It took everything in my soul not to be like, oh my God, this is the greatest show I have ever seen. I need to know everything. I was dying. I was like, production has all the tea. I wanted to know everything. Is that completely inappropriate for me to ask? Yes. Did that person try to get out of jury duty on a hardship because they had to work? Also, yes. And I was here for it. I'm like, you're doing the Lord's work. Get back to Jersey Shore. I need to know everything. Like OG. Oh, I love it. I love it. Emily, really? Yes. I love it. I love it. It's not a life I lived. I enjoy watching it on TV. Old school reality TV where nobody's running their own production lines and people are just messy. Hilarious to watch. Hilarious to watch. Oh yeah, chat GTL. GTL all day, every day. Loved. Just a peek into a life that was not mine that I enjoyed very much. That's what reality TV used to be. And now I find, honestly, a lot of the reality competition shows to be more enjoyable because reality TV doesn't feel like a peek into anyone's reality anymore. It feels like an unscripted show. But Boston Rob on Traders. Oh, I've not seen anyone from Jersey Shore on Traders. Oh my God, would that be hilarious? Yes. And then I got sucked in, chat. It's not your fault. I don't know why I said it like it was. I got sucked all the way into Deal or No Deal Island. Y'all told me. All the way in. Sucked all the way into Deal or No Deal Island. I'm invested. But it makes me love reality TV the way I used to love reality TV. These competition shows, I just love them. I just love them. Love it. Love it, love it, love it. So, Magnus had asked this earlier about the Supreme Judicial Court. Will it impact further trials? The ruling won't, but I think the practice of polling the jury might be something that attorneys ask for more. So I think it'll change how people do things in practice. Let's see. Katie Jean said the answer is always no unless you ask. And that's, I think, reminding everyone that they can ask questions when they're on jury duty is hard. It's like remembering that you are the essential part of the system. When you are a juror, you are the essential part of the system. It might not always feel that way, but you are. Even if you are stuck in the hallway waiting and the judge said, be there at 1:30 and it's 2:15 and you're like, what the fuck? I know. Courts run late. It is really frustrating, but jurors are an essential part of the system, and being able to ask can feel intimidating, but being able to ask is necessary. Blake asked, was the decision unanimous? The decision by the court was the decision of the court. They did not say how many judges voted which way, but the decision is the decision. Let's see. Kira said, my stepson is telling my husband who Kendrick Lamar is. I chime in with some info and then ask my husband, guess how I know? And he says, because there's a lawsuit. That's right. That's right. Because there is a lawsuit and we covered it. Oh, the lawsuit. The lawsuit. Katie asked, how does changing precedent become the standard? How does it become commonly accepted in the court of law? It has to go through case law and it has to go up generally to the Supreme Court of the state or the circuit court or the U.S. federal Supreme Court. And they say, we interpreted this way and we are interpreting it now this way. And then in law school, you spend much time on what is binding precedent and not binding precedent, because what you do in the Ninth Circuit is not necessarily what you do in the Fifth Circuit. So, and then there is precedent for your state, your federal jurisdiction, and then like law of the land. So it's nuanced and it requires research, but it is through the process of case law at the appellate and circuit court level. Let's see. Murdaugh asked about jury deliberations. Mardo, they did. We talked about it a couple times. I want to talk about it again. The reason is because there was external influence. External influence is one of the very limited exceptions to that. And they didn't ask about deliberations. They asked about the external influence. Kelsey said, if Drake sues Kendrick, will you cover it? I covered briefly the intent to sue. I will cover the actual lawsuit too. But yes, I don't think he's going to sue Kendrick directly. Let's play that out. If Drake sues Kendrick Lamar, what is the defense? Because it would be defamation, right? That would be the lawsuit. It would be defamation. What's the defense? Right. Truth is a defense. And then it dredges everything up. So then it becomes depositions and witnesses and discovery. Then. So, yeah. And some of it's opinion. So then you'd go through the lyrics of the song and be like, well, what's opinion and what's an allegation? And is it stated as true or is it stated as shade? Is it name calling or is it allegation of a crime? It would be a lot, and the discovery would be a lot. So when I'm putting it on the list, y'all have asked great questions. I'm putting it on the list to cover Drake suing UMG and going through what it looks like to sue the label and not the artist. It's kind of like suing the newspaper, but not the person who said the thing. So we can have that conversation. It's a conversation that that you guys want to have. I'm here for it. So we can talk about it, but sometimes suing the publisher for defamation and not the speaker is not easy. So I don't know. At some point, how much more of a spotlight do you want to shine on it? Because for a lot of people, I think it would be like, oh, I don't know any of these people. My husband, I don't know who any of these people are. My husband's like, Drake, I don't know. Kendrick Lamar, I don't know. He's like, I don't know. So for my husband, if he's looking at those songs and if he's picking up the lyrics, which is not always true, he's going, oh, there's a beef. Okay, they're name calling. So my husband's not going to go any deeper than their name calling. He's not going to be like, is that true? Is that not true? He's going to be like, okay. But if you sue, you are going to get into all of the spotlight being shined on. Is this name calling? Is this allegations? Is this fact? Is this just spilling the tea? And it brings it to a much wider audience. And then we're going to go full Streisand effect, right? So I don't know. if it's going to be a problem. Emily Ippolito in the chat said, technically Kendrick said, I heard you like them young. He did call him a certified pepito though. There is that. But we, you guys, all of you are like, let's add music court. Let's add music court. We'll add a day of music court. We'll go through the lyrics. We'll talk about if they could be defamatory, if they're not true. We'll talk about if it's shade. We'll talk about it if it's opinion. A minor is a chord. I mean, music. We can do a music court. We can do a music court day. I think we need it. Too many murder cases. We'll do a music court day, chat. We'll take the copy strikes. We'll listen to the music. It'll be fine. I played it in the podcast and they're like, this can't be monetized. And I'm like, that's okay. A minor. All right. The song slaps. So why not? All of you are like, yes. Oh, that's fair. Yay. Like YAY said, also it's certified pedophiles, not pedophile. We'll do a lyrical breakdown. Let's do it. We'll do it. It'll be good. Katie Henderson said, Karen Reed's appellate attorney indicating they might seek a federal writ of habeas corpus to the U.S. District Court. What would that mean for the April trial? Probably nothing. It would probably keep it going. The April trial is not going to get bounced, and I don't know if they will. The law is pretty settled. AH in the chat, I appreciate this comment so much, so I wanted to highlight it and bring it up. I didn't think you could ask questions, and now I know that I can. Thank you, Emily. It's why we talk about these cases. Because if y'all feel like when you're on jury duty in court, you can ask, I hope it takes some of the stress away from being in court, because court can be stressful. I hope it empowers you to just ask questions. Don't sit there and be like, oh, I probably shouldn't ask this. Ask. You need to be informed about the process too. You have the right to be informed of the process. It is okay to ask. Some judges can be really rude, but that's not on you. That's on them. And remember, a lot of them are elected. B2, thank you for the gifted memberships. I mean, I worked with a DA. A judge was a total dick to her. He was not always easy. And she said, you know what? Fine, I'll just take your job. And ran against him and won the election. I'll just take your job then. Lawyers can be petty. Often lawyers can be petty. Let's see. Magical Mary said, does judge have discretion to accept a partial verdict? Yes, they do. And yes, they can. Yes, they do. And yes, they can. Will Newman, Jughead, that took me a minute to parse the last one. Will Newman, Jughead Jones. Maybe I'm being too logical. No, but surely if there are multiple charges, that this would increase the possibility that there could be a split decision. And so the judge should be asked. I don't disagree with you. I don't know why it is their choice to just not poll the jury when there's a hung. It was the common practice where I practiced. It is not their common practice. Kelly Garcia, thank you for sharing this with us. I was diagnosed with ADHD yesterday at 45. My life makes so much more sense now. This is how almost everyone I know who was diagnosed later felt, especially when a lot of us were growing up. They looked at ADHD only as particularly hyperactive boys who were physically hyperactive. They did not look at racing thoughts and distraction and executive functioning. They did not look at the ways that particularly girls masked ADHD and the way it expressed differently in different kids. They only really looked at these kids are disruptive, which is a whole other sidetrack of like, can you please medicate them and make them sit down? I have a lot of feelings about that too, but it was only targeted with kids who were disruptive because it feels to me like the thought was that they are a problem that needed to be solved versus let's find out how different brains work and empower everyone. But early days, it was, this is a problem that needs to be solved. And I don't think that's the case. I think we all deserve to understand how our brains work. No matter how your brain works, you deserve to understand. Do you visual process? Do you audio process? Do you struggle with audio processing without visual processing? Do you have pictures or no pictures in your brain? Do you have an inner monologue? Do you not have an inner monologue? Do you, like, what, how do we work? I know more about how my car worked generally when I was 16 than how my brain worked. And even then I forgot to put oil in the car. So, same with the humaning. Thank you, Michael. G is very excited about his birthday. Number one bailiff said, when there are multiple counts, can an attorney ask the judge to query the jury on each count? Yes-ish. It would generally be, are you hung on all counts, yes or no? And then some juror somewhere someday will be like, yeah, I am. That's what she said. I'm teasing, not really. The judge could ask, have you reached an agreement on any counts or none of the counts? There are ways the judge can ask. So, I saw this question in the chat that I thought was, my inner monologue won't stay inner these days. That's fair. Sometimes the inside thoughts are outside thoughts. But I saw a number of you say, wait, there are people who don't have inner monologues? Yes, there are people who do not have inner monologues at all. There are some people who think only in pictures, not in words at all. It's brains are different. It's great. I also think it feeds to a lot of misunderstanding. Yep. I also think it feeds to a lot of misunderstanding because if we don't understand how other people's brains work, and we don't understand that everybody experiences the world a bit differently, it makes it harder to reach understanding with one another. And the misunderstandings cause so many problems. I could go on about that forever. I try to just remind my kids, not everybody experiences the same thing the same way. And it's okay to ask. And that might make it easier. If the jury is told all or nothing, then they are not going to know that they can say in their note that they have a split decision. I agree with you. I think the way the jury instructions are written is bad. I think that is a problem. I think it was difficult to understand. Agree. Music to My Soul said, shouldn't the judge still have confirmed with the jury that they were unable to reach a verdict on any of the counts? They don't have to in Massachusetts. And in fact, it is the exception, not the rule. So it says the jury may be polled if the attorneys ask, and the attorneys did not ask. And they didn't. There's no evidence that they did. The attorneys did not ask. And the defense did not object. Did not object to the, I got fuzz on my lip, did not object to the mistrial. And that makes it hard too. Let's see. Michelle said, well, I agree there was no indication that they were only deadlocked on one of the three counts. By definition, I feel that makes the jury note unclear. Fair enough. I can understand, now I'm fuzzy. I can understand where the court read that note and went, oh, they're unable to reach verdicts. Like, I get it. Sudo said, do you think the jury would have been more likely to mention reaching a verdict on some of the counts in one of their notes if the verdict form had not guilty box to tick as a verdict option? I don't know. I would need to pull those back up to look at it because on some of it, it did have not guilty at the top. Nana Banana 9, almost 3 years. Yay. Ann Bell said, how will Proctor's behavior employment factor into the new trial? It'll be addressed that he's undergoing disciplinary proceedings, for sure. Addressed a lot. But if he's not been terminated yet, then they can't say what the outcome of the proceeding was. But it will come up. The jury note says charges, not counts. That's fair. Couldn't have meant what they said, and they agree on lesser charges, not the counts. I think so. Is there a legal difference? No, because the judge is going to look at that as the jury saying they can't agree. And when the attorneys didn't say, let's poll the jury, the judge likely thought everybody was on the same page. It's easier to look at it more closely now because there's hindsight to be had. At the moment, the jury seemed very clear that they were hung. EDB, have you been on a jury? No, I haven't been. I've been to jury duty. I have gone to jury duty, but I have not been on a jury. I would love to. Put me on a grand jury. I would miss y'all. But yes, I want to be on an investigative grand jury. It's like tea. On an investigative grand jury, you can issue subpoenas, you can ask for more information, you get to like do all the things. Crocker, thank you for the gifted memberships. Is the Law Nerd Shop down? It's not down. It will be back. It is repopulating. Jessica, thank you for the gifted membership. What are the chances the Commonwealth is fighting this because they already destroyed it? I think that the reason the Commonwealth won't image the entire computer is because they want to narrow it down. The Commonwealth seems to have already said clearly that they only have the videos. They don't have the metadata from the DVR. It seems that was clearly communicated. So it's just now narrowing it down. Chrissy said, sidebar, Nickelback also loves the sea shanty version. I didn't know that. I watched them watch it in an interview and they were shook in the best way. It's so good. I'll have to go find that. I love the Nickelback Rockstar sea shanty version. Paige said, if not Brady, why Brady shaped? We are going to get into all of it in the motion to dismiss. I want to look at the case law specifically, but yeah, there are issues. There are definitely issues. Do you believe if the only charge in the first trial was manslaughter, she would have been convicted? I don't know, but I think on some of the lesser includeds of the manslaughter charge, some of the lesser includeds can make sense to a jury with the fact pattern. I think they went way overcharging here. And we see that with the jury saying that they just cut out the top and bottom charge and we're debating that the manslaughter charge. And the manslaughter charge has some confusing elements to it. I did a whole stream going over it. There were some confusing parts to it. And none of the attorneys took the time to break it down in the closing. And I think if they had broken it down in the closing, there might have been a different result. Because I think some jurors could look at this and be like, she drove him to the house and dropped him off. And where do we go from that? Where do we go from right there? So we'll see. Yeah, we'll see. Yay. Drove Pauly D in Vegas and was deeply disappointed. Oh no, I'm sad. I'm sad. Ice Baby. One of them was doing something with Chippendales in Vegas. I remember we were talking about a Chippendales lawsuit and we pulled it up and I was like, wait a second, it was Vinny that was, I think, doing that. It was very interesting. Very interesting. Luna, it's good to see you. Thank you for the very kind super chat. My 9-year-old asked me what makes him disabled, and I used your metaphor about the different operating systems. I used Apple versus Android and how most of society is set up to support Apple, and some don't even know they're Android, and frustrated when they can't function in an Apple world. Luna, I think that's a great explanation, and I hope it helps to normalize that the world is just set up for a different operating system, and it makes it really hard to function. And there's not always cross-compatibility on the two. And I hope it helps normalize it, that it's not something wrong. It's just a different way of operating. And it is a challenge, because it is a challenge. And I also see the world moving to accommodating all of our different operating systems because we're more vocal about it. And we know. And the more we know, the better we can do and the better we can advocate for us. So I love that. And I hope that your 9-year-old was like, that makes sense. Love it. And thank you. Rhonda said being on a jury is fascinating. Are you populating with zippered hoodies? There are zippers involved. That's all I'm saying. There are zippers involved and you will know soon. There are zippers involved. There are zippers involved. Marcelo said, isn't the defense entitled to the whole computer since that retired cop made it relevant by putting it in there? Because how do they know there's not more in there? That's going to be their argument. But I understand the Commonwealth's hesitation. So that's going to be the argument. And then the court's going to have to decide. And I think letting the court decide is very helpful. I think that's the way it has to be when they're asking for the whole computer, because I think findings need to be made by the court. So I love that Jessica's on the replay crew as I'm still live. That means we've been live for too long. Oh my goodness. We answered like 45 minutes of questions. Chat. You guys are the best. We are going to watch court tomorrow. I will put up polls about what we cover on Thursday, because we're going to run into some timing crunch on what we're going to cover. But next week on Tuesday, we will be live in court for Karen Reed. So we'll be streaming a little bit earlier. My favorite thing ever. So Tuesday we will be in court with Karen Reed. And then I will probably be a little bit shorter on stream on Thursday to accommodate kiddos, because my kiddos have like mid-winter break, because why wouldn't I don't even know. We have kiddo stuff. So Wednesday we are going to court tomorrow. Thursday we will be covering one of the many topics. And then next week there will be quick bits on Monday. We will be in court on Tuesday. So that's what's coming up. Members, keep an eye on your member spaces. We have info for you. Everyone who's not a member, I appreciate you. We will have some information for you later this week. Do not worry. You are not going to be left out of the loop. But Monday there will be Monday is President's Day. There will be a new quick bits for you. So stream tomorrow will be 11 a.m. because we're pulling from court today. So it'll be 11 a.m. because it'll be done. So I will see you guys tomorrow. We've got lots to talk about with Donna Adelson, who's also getting ready to go to trial. So we will see you in court tomorrow. Law Nerds, you're the best. Thank you to my mods. Thank you to the members. Thank you to Miguelina, my amazing producer. And Law Nerds, thank you for putting up with me while I am sick and distracted. I appreciate it. I'll see you guys tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.